Pronouncement of judgment, item number 1.
In due consideration of the material facts in the instant case, as well as the objection raised by the learned PP, this court is of the considered view that substantial justice may not be served with the aforesaid proceeding against the accused petitioner in connection with their case number so and so, under so and so, corresponding to it is allowed to go ahead with this case. Accordingly, the entire criminal proceedings against the accused petitioner in connection with so and so is hereby set aside and quashed. The instant petition filed under 528 PM is a sense allowed.
Deeply obliged.
Item number 2.
In view of the aforesaid factual matrix, submissions made by the learned counsel for the parties as well as by the law settled by the Honorable Apex Court, I am of the considered view that this instant petition does not make out a case on merit to be allowed, as the instant petition is hereby dismissed as rejected.
Item number 3.
Considering all aspects of the matter in their entirety, including the submissions made by the respective counsels, materials brought from record, and the case laws that have been discussed herein above, this court is of the considered opinion that instant petition filed under 528 PNSS deserves to be not entertained at this stage, and therefore the petition stands dismissed as rejected.
Anybody want to mention the matter?
May it please your lordships. With the consent of the other side, I beg to mention item number 15 of today's list, your lordships.
Item number 15.
1515. With the consent of the other side, the kindly matter be taken after 2 weeks, your lordships. I have having some personal difficulty today, your lordships.
Item number
1515. I have taken consent of the other side, your lordships.
Learned counsel appearing for the petitioner. The matter stands adjourned for 2 weeks.
There is an interim. There is an interim order that.
You are appearing for
I'm for the respondent number 2.
yeah, PP.
No, lordship. It's for SIT, lordship. SIT.
Mr. So and so appearing on the Loma Kurdu.
Yes, I'm his associate, junior associate, lordship.
So and so appearing on behalf of Standing Counsel Society doesn't have any objection to the prayer so made. The matter
There is an interim order.
matter may be listed after 2 weeks. Interim order so passed earlier shall continue till the next date of fixing.
Deeply obliged. Deeply obliged. Deeply obliged.
I beg to mention one unlisted anticipated bail application for transit bail. Today I'm filing. I may be allowed to take away the last item.
Yeah, well, we'll take it up tomorrow.
My lord, here one 35 clause 3 notice has been served by the Nagaland police to the through OCPS Nahalagan, and their specific date is given. So I have to reach there at Dimapur on 29. So this petitioner is the elected mother. So that's why we want transit bail from the Honorable Court, and we have in order to appear before the Nagaland. So for that, this is an urgent matter.
Lordship, I beg to mention item 16 and 17.
16 and 17, yes.
Yes, Lordship, I am referring for the respondent number 2.
Respondent number 2, yeah, Mr.
Titamin. I have taken consent from the petitioner also. Lordship, kindly fix this matter on the 16th September.
16 September.
Yes.
This week, I mean, when a council appearing for the respondents was submitted that he has some difficulties
Yes, file record has been misplaced.
arguing the matter today. And prays for adjournment of the matter for 2 weeks. He has mentioned that he has already taken the consent for the council for the petition. Prayer is allowed to list these matters, list this matter after 2 weeks.
16th September, Lordship.
List this matter on 16 September. Item number 16 and 16, 17. Yeah.
Highly obliged.
Same parties, same. Yes. Yes.
Yeah, Lordship. Lordship, I beg to mention item number 23, Lordship.
23 years.
Yes, Lordship. Here, Lordship, I'm mentioning on behalf of M. Kato, learned DSGI, Lordship. Lordship. And I've informed the other side also. This matter may be taken up after 2 weeks.
Mr. So-and-so appearing on behalf of Mr. Kato, he is with Mr. Giri of India. India. He prays for
2 weeks.
2 weeks. He prays for 2 weeks time. As Mr. Kato is not in the position to argue the matter. He has already taken consent from the other side. Prayer is allowed. Please this matter after 2 weeks.
Highly obliged.
Your Lordship, I would like to mention one unlisted item, Your Lordship.
For
It's
what?
the RSA application 11 of 23 along with RSA application 12 of 23. Your Lordship,
What is the urgency in that?
Your Lordship, the previous proceeding was on 05 of June, 5th June of 25. And it was to be taken up after 3 weeks. But today it's August. So it may be taken up on 28th of August.
28th of August.
Yes, Your Lordship.
22nd of August.
Maybe 27 will also, Your Lordship.
Maybe after, maybe the first week of September.
First week of
First week of
August.
First week of September. First week of September.
So, Your Lordship, I would like to mention item number 12. I'm
Number 12.
appearing for the conducting counsel for the respondent. The counsel is an
Mr. Talo.
he is the local counsel, Your Lordship. Mr. Rakesh Dubey is the outstation counsel in this case. So he could not be
Rakesh Dubey is
present.
appearing for whom? The respondent?
Respondent, Your Lordship.
Yes.
So he could not be present today. So matter may be taken out after 2 weeks.
Mr. So-and-so appears on behalf of Mr. R. Dubey, the learned counsel appearing for the respondents.
I'm for the plaintiff, Your Lordship.
Yeah.
I'm appearing for the plaintiff, for the appellant.
Mr. So-and-so appears for the appellant. The learned counsel submits that Mr. Dubey could not be present in the court. And therefore, prays for 2 weeks time. The prayer is not posed by the counsel for the appellant. Prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, Your Lordship.
Obliged, Your Lordship.
My lordship, I beg to mention item number 9.
Item number 9.
I'm appearing on behalf of Mr. Omodi. He is having some health issue.
Which one is that?
Cake recom.
So-and-so appearing on behalf of.
Matter may be leads for 3 weeks. Yeah. I have taken the consent from other side, my lords.
So appearing on behalf of Mr. Paul Modi, the leading counsel in the matter. He submits that Mr. Modi is having some health problems. And he has obtained the consent at the other side for adjournment of the matter. This 60 as paid by them, the matter will be listed after 2 weeks.
Your Lordship, may I mention item number 10?
Item number 10, yes.
Yes, I'm for the respondent here.
Yes.
I've taken the consent from the other side also. Since conducting counsel, Mr. Arsona is out of station. So kindly this matter may be adjourned.
Mr. So-and-so appearing on behalf of Mr. Arson and the learned counsel dealing this matter. He submits that Mr. Arson will be disposable today. And he has already taken the consent for the petitioner. The counsel for the petitioner. Prayer is allowed. So this is the matter of proceedings.
Right.
Mayor, please, I beg to mention item number 20. I'm
Item number
20.
20.
I'm appear on behalf of leading counsel OMOD.
So item number 19 and 20 both are connected matters.
Yes, Lordship.
So you are appearing in the both the matters or one matter?
A respondent.
Which matter? Item number 19 and 20.
20.
both are connected.
20.
19 who is appearing?
I'm 19.
And appear-
In 19, I'm the respondent, and 20, I'm the petitioner.
So you don't have any issues
Uh,
with the prayer.
Yes, no,
Mr. So and so, you are Mr.
TCBO.
You are there in the case.
No, I have been instructed to take an adjournment on his behalf.
There are 4 counsels are there. You are appearing for whom?
OMOD.
For Modi. Mr. So and so appearing on behalf of Mr. O Modi
Matter may be fixed after 2 weeks.
and Mr.
BCBO on behalf of T. Tucker.
Mr. Sido on behalf of Mr. T. Taki. The prayer has been made by the council appearing on behalf of Mr. O Modi, but he is not. These are some real cases, huh?
Yes.
So O Modi is not keeping well. He prays for 3 weeks adjournment of the matter. The prayer is not accepted by the council for the petitioner. Let the matter be listed after 2 weeks. 19 and 20.
May I, my lord, item number 22, this matter may be fixed after 2 weeks. And,
Mr. Panging is not there.
I'm appearing on behalf of respondent.
You have taken the consent for the consent from Mr. Panging.
Yes, sir.
My lord, we are appealing for the petitioner, your lordship, for the appellant, your lordship.
You are appearing on behalf of Mr. Panging.
Yes, your lordship.
That's so and so appearing on behalf of the respondent. Submits that. Submit that he has already taken consent from the council for the petitioner. That pays for 2 weeks time. The prayer is not objected by the council, so and so appearing on behalf of the petition. The prayer is allowed to list the matter after 2 weeks. Not apply to that.
Item number 4.
But yes, Mr. Secretary. Well, here I'm challenging the order dated 18/7/2025. Is at page 46. But the facts of the case is such that the respondent number 1 here in Melod entered into an agreement with the respondent number 2, who has been made Melod performer respondent. And there's a clause, arbitration clause exists, that your lordship will find the agreement.
But Mr. Secretary, it's a settled law now
But
that subcontractors as well as sister groups, though they may not be a party in the arbitration agreement, but they can be.
so here, totally it's separate. So far as I am concerned, I was initially under
So
the,
it was the same contract.
I was given 49%. That has been completed
You have been given 49% by whom? There are principal contract.
by the principal contract.
Yeah, the principal contract is still involved in the contract.
He is still involved. Then he has executed another contract in favor of the respondent number 1 for the remaining 10% of the work. So now the dispute is,
No, let me understand properly. I mean, first contract, see, that means initially the contract was given to the one principal contractor, that is, his name is, he is the
performer respondent number 1,
joint venture, no?
lordship,
That was the joint stock company.
lordship.
Then, after getting the contract from the employer, he subcontracted it to you,
To me, to the extent of 49%.
10%.
Yes.
And in that effect, one agreement was signed,
Agreement was agreed.
sub-agreement was signed, subcontract was signed between you two.
Lodge.
And that 49% of the work, it means like that work was separated, divided into two contracts.
Actually, as per the agreement, the principal contractor can only subcontract to the extent of 49%. 49%. Remaining, the principal contractor has to do of its own. So far as 49% is concerned, that was executed in my favor. I have executed, I have completed. Now the instant agreement is being entered into by the joint stock company with the respondent number 1 for execution of the remaining portion of the work, that is about 10 kilometers as such.
That should be, I mean, that should be 51%, then he should be completing.
No, the remaining is on the remaining respondent performer respondent number 2 has done. Only remaining 10% was there. That portion has been subcontracted to the respondent number 1. So that's the agreement, my lord, will find at page 28. My lord. And in fact, in the application, I'll take your lordship also. He does not make any claim against me. This is the agreement, my lord. The joint stock company, first party, then Hachang Tasang, respondent number 1 herein. So this is the contract. So we'll find paragraph 3. The second party is a first-class contractor construction of firm registered under PWD. Second party has agreed to undertake construction of remaining 10-kilometer work under above said work of the first party. Obligation or so project desires to sublet the second party to perform and execute the remaining construction work of 10-kilometer stretch of the said project at an amount of rupees 39 crores only without escalation, and 52 crores only with escalation, etc. The second party, being duly competent and experienced in the execution of such work, agrees to undertake the remaining work in terms of the conditions stated below. Now here there is a clause, that is clause number 6 at page 31.
Yes.
That in case of any dispute between the parties, the dispute shall be settled through arbitration within the jurisdiction of Guwahati High Court, Itanagar Permanent Bench. So now the dispute arises between the joint stock company and the this respondent number 1. So he has filed the petition, my lord, at page 12. Now, lordship will kindly, it's a long one, but I'll just take your lordship to paragraph.
So this is this arbitration petition has been filed by that
Respondent number 1.
respondent number 1. That was the person who has completed 10% of the work, supposedly.
It has not been completed because he
has some dispute.
Yes,
Some dispute.
yes, some dispute.
He was given 10% of the work.
10% of the work. So there's a
So
dispute.
he has gone to the court.
Gone to the court, my lord, seeking, my lord, this interim order under section 9 of the act.
And your party is tenor engineering.
Mine is tenor engineering. I have been made a party, but your lordship will find, my lord, entire the petition. There's absolutely no claim against me. I'll just few of the, my lord, clauses. Paragraph. I'll take your lordship. My lord, paragraph 16.
No claim against you, and you have completed your 49%, and you have
Long back.
paid for this.
Yes, yes. I
Long time
lordship.
back.
Here,
There nothing remained for you to do in the contract,
nothing.
and there is no dispute between you and any of the parties.
Any of the parties.
But only thing is that you have been made party just like that.
Just like that. That is what, my lord, the abuse of the process of the court, my lord. This paragraph 16 will make
So at this stage, we'll issue notice.
it. When further, my lord, my pray, my lord, that arbitration proceeding may can be listed. It's a total abuse of the process of the court. They are all made performer respondent as they were.
So can you take me one thing, show me one thing? I mean, this arbitration petition, where are the prayers? What is the prayers and what?
Yes.
And like, is there any statement why you have been made a party?
My lord, it is not there. My lord. That's what, my lord, lordship will make it very clear, my lord. Paragraph 16, if your lordship looks into, my lord, at page 23.
The page 23 is the prayer part.
No, my lord, this is the body of the petition.
Yes, yes.
Look.
Here nothing has been stated about it.
Nothing, my lord. Paragraph 16. that the petitioner back to state that the dispute between the petitioner and the respondent number 1, that is Bojros the email, that joint stock, is such that request to be settled by way of arbitration. It be further stated here in that clause 6, that is the arbitration clause of deed of agreement dated 29/8/2024, state that in case of any dispute between the parties, the dispute shall be settled through arbitration with the jurisdiction of the Guwahati High Court, Itanagar Permanent Bench. Then 17, in view of what has been stated here in above, the petitioner has been compelled to approach this court as there is a need that the subject matter of arbitration be preserved from the arbitral tribunal as constituted. Then 18, that the petitioner back to submit that if in the meantime the respondent number 5 keeps on disturbing payment in favor of the respondent, disbursing payment in favor of respondent number 1 in respect of the project work, even after the letter dated so and so was issued by the respondent number 4, directing the respondent number 5 not to forward any bills related to the project, the same will have adverse consequential action on the claim of the petitioner, who in fact was the entity who had actually completed the entire contract project work except subventionary bills, and the same would not only highly prejudice the petitioner but would also defeat the purpose of a proposed arbitration. The amount in dispute is therefore required secured. This is all the more important because the respondent number 1's bank guarantee is also not valid, and there is every likelihood that he may dispose of, remove of all the property and flee the jurisdiction to defeat.
But your case is that like that money, whatever money you were supposed to get, you have already received that money.
All this statement, what have been given, it is against the respondent number 1, that is joint stock. And rather, this has been made very clear in paragraph 15. Your Lordship will kindly find, my lord. Paragraph 15, again, my lord, page 23.
Yes.
First paragraph, my lord, from the bottom, 7th line.
It is needless to say.
Yes, my lord. It is needless to say that respondent number 1 today cannot shift the burden of claim of the petitioner on the respondent number 2, that is me. So you cannot say that subcontract is something. Even he himself has said. On one hand, they accepted the petitioner as a subcontractor. On the other hand, have kept the avoiding the answering the request raised by the petitioner regarding payment of the legitimate due. So he has made it very clear that the respondent number 2, that is the.
And what was the order passed by the Learned Trial Court?
Lordship will find at page 46. The court did not consider the implication of section 9 or the parties who are the necessary parties or the proper parties. The court has only gone, to the order 1 rule 10, as is in general, at page 46. All these submissions, have been made, in paragraph 2. Paragraph 3 onwards. I have carefully perused the application filed by Messrs. Tenor Engineering and also perused the arbitration petition 2 of 25 along with the annexed document. It is observed that initially the contract work was awarded to the Messrs. Joint Stock Company versus Denny, and out of the entire contract work, Messrs. Tenor Engineering was awarded subcontract to the tune of 49% of entire works order. It is observed that from the records of the case that initially the petitioner Hassan Tasang was engaged by Tenor Engineering as subcontractor for carrying out the contract works was awarded to Tenor Engineering by Joint Stock Company I Bhadrasdini. It is also observed that later on the petitioner Messrs. Hassan Tasang has entered into an agreement with the respondent number 1, Messrs. Joint Stock Company Bhadrasdini, for carrying out the remaining work order. It is the plea of applicant that he has not received the bill for the work performed by it from the respondent number 1, Joint Stock Company Bhadrasdini, and respondent number 2, Messrs. Tenor Engineering, are there as there is arbitration agreement between the parties. The petitioner Hassan Tasang approached this court for an order of interim protection as provided under section 9 so and so till its grievance not resolved through the arbitration proceeding. It is observed that from the prayer of the arbitration petition, the relief claim both against the respondent number 1 Arbitration and Conciliation Act and the respondent number 2, Messrs. Tenor.
This claim both against respondent number 1 and respondent number 2. So where he is saying so?
He is saying because in the prayer, your Lordship will find the prayer is of the petition. Then as a prayer has been made in that page
Page
25.
25.
Gotcha. That clause B, restraining the respondent number 3 to 5 from releasing any bill to the respondent number 1 and 2 in respect of engineering program. I have nothing to do with these bills, my lord. My work has been completed long back.
Three to five of this employer.
Yes, my lord, they are the employer, so they are,
You have already received your bill.
I have received, I don't have any dispute, nor he is claiming as my lord to have already in paragraph 15 that you have seen.
Okay. Third, Mr. PJ Sakhel and its senior counsel appearing on behalf of assisted by so and so appearing for the petition. MS so and so appears on behalf of respondent number 3.
But 4 also can be. 4 is chief engineer, highway. Executive engineer. So,
For 4 also you can appear probably.
except PWD, they have.
For the highways, there is
It's a highway or it's a public works department? It's public works department, it's not highway.
Highway division.
Highway, 5 is different. Executive is 0 highway division.
5 is also one state of Assam.
Highway
State of
division.
Arunachal. But
You can appear for 4 and 5. No, you are not, yeah,
perform.
that's what, so and so appears for respondent number 3, 4 and 5. Performer respond. The petitioner herein has filed this petition file this petition under Article 227 of the Constitution of India, read with Section 151 of Code of Civil Procedure Code, being aggrieved by the order dated 18/7/2025 passed by the Landed District Judge, UPA, Arunachal Pradesh, in this case number 31 of 2025, arising out of arbitration number 2 of 2025, whereby the petition filed by the petitioner under order 1 rule 10(2) of the Code of Civil Procedure was rejected. The case of the petitioner is that where is that arbitration agreement? That initial arbitration agreement that you entered to?
Page 28.
The case of the petitioner is that it entered into an agreement with MS Joint Stock Company. Let me write the spelling BOZROZHENIE. Respondent, the proforma respondent number 2. Herein. No, Hachang Talang is who? Hachang Talang.
Respondent number 1, madam. He has filed.
No, I'm asking about the agreement that you entered with the.
Well, that has not been annexed.
Is there any details of that? That should have been here because you have performed that contract. You have executed the contract.
No, this is an
And what were, huh?
this is an admitted position, my lord. In the order also, it reflects in the petition also, it says, my lord.
That should have been here.
Petition itself. So,
See, there is one problem here. So, Satya,
Gotcha.
in the order, it says that it is observed from the records that the case that initially initially the petitioner, so and so was engaged by Tenor Engineering, a subcontractor paying for filling out the contract.
gotcha. That was while I was as the subcontract, I have further subcontracted him, my lord, for the purpose of 49%.
Cut out that line.
Now the entire, my lord, this petition has been, my lord, initiated on the strength of this agreement, my lord.
The only thing is that they must have thought that this Acham Engineering was engaged by your company initially.
No, but I was only to the extent of 49.
Correct.
They have
That's
given me
correct.
everything, my lord.
Yes, I understood that.
Good.
So now Acham Engineering was again given 10% of the work.
10%.
The remaining 10%.
Remaining the 51 to be executed by the principal contractor, while the principal contractor was executing the remaining 10%, what was left over, that was given to Hassan Kassan by this agreement.
We'll take it down. The case of the petitioner is that the petitioner was given a contract by the performer respondent number 2. That is that name I have given, respondent number 2, for executing a work. Executing a work. What was the work that the highway?
Lordship.
Executing a work for construction of a highway. Construction of a highway. Can you give me the details?
Lordship.
You just give the
I have given in paragraph 1, my lord.
paragraph 1.
Lordship. This is construction of
Construction of 2-lane road
Lordship.
to no. Okay, you take it from here. For performing certain portion of the construction work, namely construction of 2-lane road of 14-Pangin section of National Highway 13 from kilometer 160.592 to kilometer 206.66. Package 5, bracket in bracket package 5, the Arunachal Pradesh. Under the Arunachal Pradesh package of roads and highways of SARDP-NE, bracket tender ID number 2020 dash MORTH, all capital except O, dash 548201 dash 1, bracket complete. What was the value of your contract?
The total value,
Your subcontract value?
subcontract value was that 49%. Of 96 or so. Yes, okay.
So we write certain portion of the work of the contract of the for the contract value of rupees 334, 98, 51, 050 dash. It is the case of the petitioner that he has been subcontracted by way of an agreement. Agreement dated, you have the date?
Yes.
Agreement dated? Subcontract agreement?
25/9/2020.
By way of a subcontract dated 29? But the details are not there, Mr. Sakia.
The 9th day of October 2020.
19?
9th day of October 2020.
9th October 2020. By way, this is the subcontract you signed with the principal contractor, correct? I've written this 9/10/2020. In terms of the aforesaid subcontract, it is the case of the petitioner that he has already completed the contract and he has received the contractual amount from the respondent number, performer respondent number 2, that is the principal contractor. He further submits that the remaining portion of the work, that is 51% of the work, was to be completed by the performer respondent number 2, that is the principal contractor. However, about 10%, correct?
10%.
About
10 kilometers.
10 kilometers.
Remaining portion, that is about 10 kilometers.
It's not 10% of the work.
Confirmed from the agreement itself. There's 28. Remaining 10 kilometer work under above said work of the
Okay, it's not 10%, it's 10 kilometers.
10 kilometers.
However,
Valuing about 39 crores.
out of the aforesaid 51% of the work, a remaining work for construction of 10 kilometers valued at rupees 39 crores
39 crores.
was
Without any
subcontracted by the performer respondent number 2, there is a principal contractor, to the respondent number 1.
Right.
To the respondent number 1, Messrs. Hachang Tachang. By way of an agreement dated 29/8/2024. Is that correct?
Logic.
Is that correct?
Correct.
29/8/2024. The petitioner submits that he was neither a party with the aforesaid agreement dated 29/8/2024. Nor he has anything to do with the remaining portion of the work. As per his agreement dated 9/10/2020, he has completed the work and he has completion certificate was given to you.
That's good.
Given? He was completed the work, and after completion, he was duly given the completion certificate as well. Therefore, he submits that though the aforesaid agreement dated 29/8/2024 has an arbitration clause, but since he is not a party to the agreement, any case arising out of that agreement, be that as it may, he should not be dragged to the court unnecessarily. In view of the above, when a petition that is arbitration matter number 2/225 was filed before the district judge Apumpare at Rupia, and he was given a notice, he immediately appeared in the matter and filed an application under
Order 1 Rule 10.
Order 1 Rule 10(2) of CPC 1908. There is a prayer to strike off his name from the aforesaid case, as he is no way concerned or needed or required in the aforesaid matter. He submits that the dispute is in between the principal contractor, that is performer number 2, and the respondent number 1. Therefore, he submits. No. Before this line, you write that when the application was filed, the application was heard, and application was heard and rejected by the district court, UPA.
Applies at page 46.
With the following observation. Para 5 of this is quoted. Para
There are 3 and 5.
I think it is wrongly numbered. 4, 5, 6, then again 5, 6. Please check the paragraphs are wrongly numbered. 1, 2,
Page 46 is
1,
the
2,
order.
3.
1, 2, 3,
Then you find 4,
4, then 5,
then 5, then 6, then again 6,
again 6,
again 5, 6.
again 5, 6.
So that paragraph will be. It is the learned counsel for the learned senior counsel for the petitioner submits that while passing the aforesaid into an order, the learned court below has in fact not considered the provisions of Section 9. Section 9 of Arbitration and Conciliation Act 1996, whereas it is totally relied on Order 1, Rule 3 of CPC. Which provides that all persons may be joined in one suit as defendants, where इसको A भी करके लिख देना है, any right to relief in respect of or arising out of or arising out of the same act or transaction or series of acts or transaction is alleged to exist against such persons, whether jointly, severally, or in the alternative, semicolon, and B, if separate suits were brought against such persons, any common question of law or fact to be arise. He submits that a bare perusal of the arbitration method number 2 of 2025 would reveal that in fact there is no relief has been claimed against the petitioner.
I would say there's no grievance of the respondent.
Relief is not, because there is no grievance, that's why there is no relief has been sought against the
Relief one has been sought in paragraph page 25, as I already taken your option.
Yeah, not to release only, no?
Not to release.
Restraining not to release, but
that is not
that is not applicable.
applicable.
In fact, it is seen at paragraph 15 of the aforesaid arbitration method number 2 of 2025 that the respondent number 1 has made a statement to the effect that it is not right in the part of the respondent number 2, that is the principal contractor, to shift the burden to the petitioner, that is to the petitioner in that instant case. In that case, it is not the case. This clearly shows that in fact the respondent number 1 does not have any claim against the petition. Therefore, he submits that not being a party to the agreement that has been signed between the respondent number 1 and 2, as well as no relief that was been sought against him in the arbitration matter number 2 of 2025. He is not a party that is required to adjudicate the aforesaid arbitration matter number 2 of 2025. Accordingly, he submits that the interim order so passed by the district judge, by the Honorable district judge, is not correct and is liable to be set aside. I have heard. You have anything to say, madam?
Yes, that's because unless notice is issued for toxic.
Correct. Got it.
That where. See, any income to the order of the. Oh, system.
Okay, you can come up with your reply when the notice is issued. Or should I record your? You want to submit on instructions, or you want to submit as of now, looking into the petition?
I submit on instruction of that, but then what I'm saying is that,
Okay, heard, also heard so and so. She submits that there is no infirmity in the order passed by the learned district judge. Yeah. Issue notice returnable within 4 weeks. Notice to respondent number, performer respondent number 3, 4, and 5 is dispensed with as learned so and so appears for them. In the meantime, after due consideration of the matter and materials not on record, this court is of the opinion that there is strength in the argument forwarded by the learned senior counsel. This court has also perused carefully the interim order as well as the petition filed by the petitioner before the district judge, as well as the petition that has been filed by the respondent number 1. That is arbitration letter number 2 of 2025. On being prima facie satisfied that there is no relief as such has been sought against the petition by the respondent number 2. In the interim, the proceedings in arbitration number 2 of 2025 is stayed.
Pending in the court of district judge.
Pending before the court of district judge is hereby stayed until any further order passes. Until any further order to be passed by this court. It is a matter of the court.
sorry, but some better particulars ought to have been in the petition. I'll be some better particulars ought to have been in the petition. I'll be supplementing it by an additional affidavit subsequent.
Because you'll have to bring on record that your agreement also. For it to have.
Right.
Because that has to be seen, like what were the terms and conditions. Is there anything that, I mean, you did not, you may not have, I think your submission is that you have already completed it.
That is there, but that is also admitted by.
But if you think so, you can bring.
Yes, yes, there's some, at least the work completion certificate may not up to.
I will just correct here and there in the order.
Okay, I'll make it.
Thanks.
Item number 5.
Lots of mayor, please.
Yes.
My lord, here, earlier bail application was rejected by special POCSO case, UPIA. And this bail application are filed when the victim was examined by the trial court. And while examining the trial court by the victim,
I mean, this case verification was done by whom? The board or the committee?
my lord, trial is commenced.
Yes, trial
Ah,
commenced.
yes.
No. Yeah.
And that statement of the victim was recorded that the victim was examined by the
Victim was-
trial court.
Okay.
Yes. And while examining the victim before the learned trial court, the victim did not disclose any offense against the present accused person. So the learned PP declared him hostile. Accordingly, victim was declined, hostile. Even
The
after
victim was declared hostile.
hostile. And the cross question was put on
How old is he now?
12 years above. Victim.
Presently, she is 12 years.
Yes, and above.
And when the incident occurred?
11.
11 years.
Yes.
And how old are you?
26. Page number.
So your only case is that he should be granted bail because she has turned hostile.
Yes, there are no such incrimination against the accused person.
So let us go to the FIR.
My lord, here, in fact,
FIR they have not
FIR is
annexed,
not
my lord.
enclosed.
They have not annexed. In fact, it's a defective application, my lord. No FIR annexed, no charge sheet,
Trial
nothing.
is going on and you are coming for a bail. FIR is not there.
Yes, only examination that is. So, my lord, I call for the records, a scanning copy from the learned trial court. So,
No, you'll have to make out a case to, direct this court
yes.
for a CD. It's not a routine case that whenever a bail is filed, then the CD has to be called. When you have to make out a case, and the first thing is that like your petition, you have not annexed this FIR.
Well, it is, my lord,
Now, how this court is going to know what was the offense disclosed in the FIR?
that
If you do not
my
know that,
mistake. That is my mistake. So, this case, I may be allowed to withdraw this, and
you please withdraw and file a proper application.
that's correct.
Mr. So-and-so appearing on behalf of the petitioner is praying for withdrawal of the application. The prayer is allowed. Mr. P.A.K. learned APP, PS on behalf of the state of AP, state of AP. He doesn't have any objection to the withdrawal of the matter. Matter stands dismissed on withdrawal.
Obliged.
Item number 6.
Yes.
My lord, this is a criminal petition, my lord.
POCSO.
Not POCSO, my lord. My lord, I have been charged with the offense of 137(2) and subclause 2,
137 kidnapping.
kidnapping, my lord. And 3 subclause 5 of BNS, my lord. 17.
137 and 3 and
Three.
5.
Yes, my lord.
3/5. I mean 3 bracket 5.
Yes, my lord.
3 is like this
Common intention,
common intention.
my lord.
Okay. Then
My lord, can you turn to page 17 is the FIR, my lord.
page 17.
My lord. May I read it, my lord?
1 second. This is item number 6, right?
My lord.
Yes, FIR is at page
17.
17. Yes.
I, Sri Sodesium, lawful father of the minor so and so, age 12 years, 8 months only, constrained, bring to your notice that my daughter has been unlawfully abducted. As she was last seen on 4th December 2024 at 3 p.m. from Hilltop Colony, Dapo region, and where above remains unknown. Upon carefully deliberation with my family members, I have compelling reasons to we strongly suspect Sri Pakje Gyadu. My lord, I am not Pakje Gyadu, my lord.
You are an accomplice.
Supposedly, my lord. Alleged. And his family members may be involved in abduction of my daughter. We same reasons to believe that this person and his family members are planning to harass her based on past incidents. After that, some unknown persons calling my daughter phone number so and so. However, this suspicion by the previous threat and action which indicates a malicious to intend to harm or exploit her, whereas their first continuous harassment of the family. It is pertinent to mention that so and so is currently under investigation for a POXO case at police station Dapo region with case number DRJPS case number 79/2024, where he is accused under section 65 subclause 1, 35 subclause 2.
That is a different case.
That is a different case, my lord. It seems,
Like
my lord.
in this case, Mr. Pakje Gyadu is not involved.
Not involved. My lord, earlier, a case was registered against this Pakje Gyadu.
Earlier, a case was registered against Pakje Gyadu.
Yes, for rape and under POXO Act.
And in that case, whether he was also a party? I mean,
No,
he
my
was
lord.
not.
No, my lord.
Now, the thing is, the allegation is that because he has been arrested
My lord.
and to harass this girl, your client has supposedly abducted her.
No, my lord. What?
That is the FIR.
Yes, probably, my lord. Now, what happened, my lord? On 4th December, my lord,
Yes, 4th December, 3 p.m. What happened?
the victim herein, my lord,
Hmm.
she called one of her friend, my lord, one Yani,
Then you were stating this from where?
my
From
lord.
the statement or what?
Yes, 161 statement. And it can be found in the page 28, my lord.
Page 28.
Page 28, the FIR, the charge sheet, my lord. Page 28.
Page 28. Yes.
It's a part of the charge sheet, my lord.
Yes.
Facts and findings of the investigation, my lord.
Correct.
During the course, married, my lord.
Yes.
During the course of investigation of the instant case, it was revealed that on 4th December 2024, the victim had called on the alleged accused phone number, not mine, my lord, Pakje Gyadu's number, my lord.
Okay.
But it was switched off. She then called her friend, Miss Yani Rai, wife of so-and-so, to inquire about the alleged accused, Sri Taje Pakje Gyadu. However, Miss,
And she is 12 years old.
she's 13, I believe.
12, 13 years old.
Yes,
And she called up this person, the accused.
yes, my lord. The,
And in that case, whether she was the victim girl? No,
yes, she is the victim.
she was the victim girl.
Yes,
And she called up the accused.
yes, she called up the accused.
Okay.
It seems that they were having an affair, my lord. And in fact,
13 years old, 12 years old girl.
it's on record, my lord. But I believe that she is not 13. She may be around 17.
Okay, carry on.
No, my lord.
It's a joint petition under
Joint
section-
petition, yes.
yes. Petition number one is the complainant.
Mm.
And petition number two is the husband of the complainant. The complainant, Srimati Mariana, lodged an FIR against her husband on 26 September 2007 or 6 September 2017.
Mm.
This was the result of a marital dispute.
Mm.
And following the investigation, a charge sheet was filed under section on September 26, 2018 against the accused under section 498A and section 324 of IPC.
498 and
324.
yes.
When the method
Where is the affair?
FIR is on page number 14 also.
Hmm. Where is that agreement? So is there any agreement between?
Agreement, Lordship. Page number 58 to 59.
Page number?
58 also.
Madam Hagi, what do you have to say?
As this is the lordship, family dispute, the husband and wife, matrimonial issue lordship. And here lordship in the settlement also they have mutually settled and they have started living as a husband and wife. So it may be disposed of lordship. Yes, lordship, because only lordship 498A is the non-compoundable and rest are compoundable. And they are the husband and wife lordship. And the cases, Bajanlal cases like that lordship where the
This will not solve any purpose, no, they're I mean, like going ahead with the trial will not serve any purpose.
That's why
Your
lordship, it will
husband and
futile
wife-
excess of the trial court lordship.
I'll dispose of this then. And you don't have any objection, no, in this?
No lordship, this is family dispute, like husband by matrimonial issue lordship.
Yes.
And then lordship, and the injury also simple as I have. gone
Simple
through the
injury,
case,
yes, I've seen that. Simple injury, long time back it happened.
Yes,
It
lordship.
happened in 2016 it happened.
Yes, lordship.
So now almost 9 years.
Yes, lordship, it's a all case lord.
Heard, Mr. So and so.
Yes, Sri Ram.
Please have a seat. I'll just dictate the order here. Right, Mr. So and so. Appearing for both the petitioners. And Ms. L. Hagil, along with APP, appears for the state of emergency. Brief facts in the case is that first right, this is an application filed jointly by the petitioners who are jointly by the petitioner in bracket husband and wife bracket complete. Under section 528 of ENSS 2023 for setting aside and quash the Itanagar WPS case number 81/17 under section 498 bracket A bracket complete stroke 323 IPC dated 6/9/2017 and any consequential proceedings out of the case on the ground that the accused and the informant are husband and wife and they have been staying together along with their 3 grown-up children after settling the marital dispute whatsoever persisted at that time between them. The brief facts of the case are that the petitioners were married in the year 1998 and from their wedlock they have 3 children. However, on 5/9/2017, due to certain misunderstandings, out of anger, misunderstanding, out of anger, the petitioner number 1, that is the wife, lodged an FIR before the officer in charge of police station, Itanagar, Arunachal Pradesh. Consequently, on 6/9/2017, Itanagar WPS case number 81/17 was registered. After the completion of the investigation, a charge sheet was filed on 26/9/2018 before the learned court of Judicial Magistrate First Class, UPA, where the petitioner number 2, in bracket the husband, was charged under section 498 bracket A stroke 323 IPC. after appearance before the learned trial court. Charges against the petitioner number 2 under section 498A and section 324 LPC. Were made from the record it is saying that the case is pending at the stage of recording of prosecution witnesses before the trial. It is seen that next paragraph, in perusal of the reports, perusal of the materials annexed to the petition, it is seen that the charge sheet was filed way back on 6/8/2015. Whereas the trial proceeding has reached the level of examination of
The prosecution witness, prosecution witnesses.
examination of prosecution witnesses. It is further noticed that write the joint application write this joint application. The petitioners have categorically stated that with the blessings of the family members of the respective families, as well as the well-wisher, both the petitioners have amicably settled their amicably settled the issues of conflict existed or not persisted existed between them. But and presently they have been living happily together with their grown-up children. It is also seen that an agreement, an agreement duly signed by an agreement, deed of mutual settlement. Duly signed by both the petitioners and notarized on 30th June 2025 before the notary public. The deed of settlement also show their eagerness and willingness to stay as husband and wife. Very. Doesn't make it first. Oops. Particularly the case that's already. क्या लिखा? The council for the submits that in view of the present circumstance that is prevailing and the willingness of the parties to stay together peacefully, keeping in mind, keeping in mind the principles laid down by the Honorable Supreme Court in the case of Lal versus State of
Haryana.
State of Haryana, reported in
Supply 1, HSC 335.
This code may allow a joint application made by the parties. The submits that though offense under section 498, 498 is not compoundable.
498 A lawsuit.
Huh?
498 lawsuit.
498 is not compoundable,
It's not compoundable lawsuit.
but other one is compoundable.
Yes, lawsuit.
307. He submits that though section 498A of the of the BNS, BNS IPC.
IPC lawsuit.
498A of IPC is not a compoundable offense. Looking into the materials before this code. Can you give me the relevant paragraph? Last case. The principle which has been laid down.
I'll provide the lawsuit.
No, yes, what have you written? For this code.
Lawsuit here, lawsuit, another citation there, lawsuit. State of Madhya Pradesh versus Lakshmi Narayan, which total 19 reported, 5 SSC 688. I can also produce it.
You have a copy with you?
Yes, lawsuit.
Just give me, I'll just. he submits that no purpose will be served in allowing the proceeding before the trial court to go ahead. In fact, that will bring in lot of hardship to the petitioner number 2. And he being the father of the children and husband of the wife, the whole family will suffer from hardships. He submits that in view of the matter, this court may allow his joint application and set aside and quash the proceedings pending before the court of which court? CCM, no?
JMFC, Lord.
Damage.
JMFC.
JMFC? UPA?
Yeah.
The court of JMFC UPA. Heard MS
And
L.
again,
Hage also she submits that looking into the materials, taking into account the materials before this court and the petitioners being husband and wife having grown-up children, and also considering the injuries minor injuries that was suffered by the petitioner number 1 at the time of the incident, which occurred almost 8 years, almost 9 years back. She does not have any objection in allowing this present application. She also,
simple lawsuit. Injury was simple lawsuit.
sorry,
Injury was simple injury.
simple that I said like minor injury, into the minor. इसमें लिखो ना, उसमें एक लिखो लर्नेड L. Hage has fairly submitted, लिखो fairly submitted, okay. Then लिखो the learned APP has also cited a case that is like the state of Madhya Pradesh versus Lakshmi Narayan, reported in 2019 5 SCC 688, wherein the Honorable Supreme Court, after taking into account the fact that the dispute between the petitioner number 1 and 2 had arisen out of their matrimonial relationship, and that they had resolved the entire dispute amongst themselves and had been living peacefully together as husband and wife. Has opined that even if the proceeding is allowed to be continued, the chance of conviction is very remote and bleak. In view of the aforesaid observation, the Honorable Apex Court, for the ends of justice, allowed the aforesaid petition. She submits that in the present case also, she submits that the case in hand is also exactly the same, and looking into the materials and recall, she submits that she submits that looking into the ratio laid down by the aforesaid cases of Bhajanlal Shukla and Lakshminarayan,
The fatal excess of the
in the ends of justice. The extent petition can be disposed of the motion stage itself. Full stop. After consideration of the submissions made by the Lorry Council for the respective parties, as well as materials on record, and taking into account the principles laid down in the opposite two cases, this court is of the considered view that this petition, that the ends of justice will be properly served if this instant joint petition is allowed by quashing and setting aside the proceeding that is pending before the learned James Court, UPI.
JMFC court.
JMFC's Court, UPI. Next paragraph. In view of the aforesaid observation and conclusion that has been arrived by this court, the instant application is allowed and disposed of. Okay. I'm just keeping it with me. Then, like, I may need to require to do a little bit of
Item number 8.
May I, Your Lordship?
Yes.
Your Lordship, this is also a joint petition, Your Lordship.
Huh?
This is also a joint petition, Your Lordship. Before going to the FIR, Your Lordship.
But all the joint petitions are not same.
Yes, Your Lordship, understand, Your Lordship. So, Your Lordship, before going to the FIR, Your Lordship, the facts I just want to highlight before this court, Your Lordship. Petitioner number 1 is the complainant in this case, and petitioner number 2 is the alleged accused, Your Lordship. They are.
Petitioner number 1 is the complainant.
Yes, Your Lordship.
Petitioner
And
number 2
is the alleged accused.
and they are relatives.
They are relative, close family relatives. They share a relationships of in-laws, Your Lordship. So, Your Lordship, this what happens, Your Lordship, there was a certain misunderstanding with regards to destroy of cultivation land, Your Lordship. Now, if Your Lordship may refer to annexure number 1, that
Annexure number 1.
annexure number 1, that is at page number 19, Your Lordship. This is an FIR, and Your Lordship may refer to page number 21. This is the readable part that can be readable, Your Lordship. If I may read only the relevant parts, Your Lordship.
Yes.
Yeah. With great pain and agony, I would like to submit that one Shri Tai Taning is an accused, son of so-and-so, village of Pagba, has attempted to murder me on the morning of 29/12/2024. Further, Shri so-and-so has criminally intimated me on their consequences. That on the morning at around 8 a.m. 29/12/2024, Shri Tai Taning has tried to kill me using local dao. And further, Tai Taning has physical assault me brutally and napping my hair and cutting and hitting my face brutally, due to which my face has got deep wounds and resulting to excessive bleeding and left swollen near my eyebrow, Your Lordship. Now, Your Lordship, on basis of this FIR, 2 sections were attracted, Your Lordship, initially, Your Lordship. One is two sections were attracted.
Correct.
1 sections were 74, Your Lordship. 74(2). This is non-compatible, Your Lordship. And another section, initially it was attracted, section 117, which is voluntary causing grievous hurt, Your Lordship. However, Your Lordship, while going through an investigation.
Now, what was the charge sheet?
Charge sheet, if Your Lordship may refer to annexure number 3, page 24.
What is annexure number 2?
Annexure number 2 is a photocopy of someone that.
Okay. Annexure number 3.
Annexure number 3, page number 24, Your Lordship. Your Lordship, this is in charge sheet. If Your Lordship may refer to page number 27, this is the main the investigation that I have laid down. Wherein, Your Lordship, after the perusal of an FIR, this detailed charge sheet has been drawn by the IO, where it has specifically mentioned that there was certain misunderstanding between the complainant and the accused. Out of that misunderstanding, there was certain heated arguments which resulted to fight between them. So there was slip of the complainant slip where she got injury on her face, Your Lordship. There was no intention, Your Lordship.
But then why did the charge sheet was filed then? It could have been FR also.
Yes, Your Lordship. Actually, Your Lordship, what happened, Your Lordship? Before the filing of a charge sheet, if Your Lordship may refer to annexure number 4, there was a written application already made to an IO stating that the matter has been already resolved between them, which is between the family matter, which was already made to an IO. But there was certain misunderstanding between the communications of IO and this concerned party. So the charge sheet has been filed, Your Lordship. So on charge sheet, if you peruse, Your Lordship, they have mentioned that the injury was also simple in nature, wherein the medical documents also is clearly states, Your Lordship.
From where the medical documents were?
Is page number 33, Your Lordship. And the next page number 34, where it has mentioned.
Page number 33.
Yes, Your Lordship. This is the documents where I was forwarded. And if Your Lordship may see the next page.
One second. Go slow.
Yes, Your Lordship.
We have a lot of time.
Yes, Your Lordship. In page number 34, it has mentioned that nature of injury is simple in nature, Your Lordship.
Yes.
Your Lordship, one point to note it out before this court that charge sheet was filed on 9/4/2024, and written application for non-pursuant of FIR was written on 26/1/2024, which was before 2 months before. But however, there was certain misunderstanding between the IO and this concerned party, so charge sheet was filed, Your Lordship. And Your Lordship may refer to annexure number 5. This is a mutual agreement between the parties, which is as page number 39, Your Lordship. This is a deed of mutual agreement, Your Lordship.
Tai Yapi is the injured.
Yes, Your Lordship. And Tai Tunning is the alleged accused, Your Lordship.
Tai Tunning is the accused.
Yes, Your Lordship. They are from the same village, residing next to each other, and they are close relative and shares a relationship of in-laws. So, Your Lordship, in this mutual agreement, if you peruse, that petition number 1 has forgiven petition number 2, being family relatives, Your Lordship. And also, because of that heated arguments and
you always injure somebody, then he'll come back with this kind of mutual agreement.
No, Your Lordship, actually this case, Your Lordship, what happened, Your Lordship, because since they are neighbor to each other, Your Lordship, there were certain boundaries. There were certain misunderstandings to their animals, Your Lordship. What happened, Your Lordship?
Calculating their.
Yes, Your Lordship. So they had their cultivating land where they used to do cultivation. But what happened, Your Lordship, there was an allegation that petitioner number 1's animal has entered to petitioner number 2.
I know, I
So this was a minor issues between them. So which was gradually they have resolved it since they are in family relations.
Yes, madam.
And Lordship, this is also kind of Lordship family dispute, Lordship, both are relative, Lordship. Here, Lordship, also I have just.
So you are representing the state, so you'll have to be.
Yes, but I am fairly submitting, Lordship. Here the statement of the Lordship accused, Lordship. I have just going through, Lordship. It was like he was also like feel sorry that it was sudden and very unfortunate incident. I realized, Lordship. That is the last portion, which I'm just looking at. Page 31.
So I'll dispose of this.
Yes,
See, like
Lordship.
they are basically they're saying in-laws.
Yes, Lordship.
They're in relation of in-laws.
And
secondly, they stay in the same village.
Yes, Lordship. And same neighbor also like.
Correct.
As
Correct.
per this record, Lordship.
And they stay in the same village. They're from the same community.
Yes, Lordship.
Something happened in the heat of the moment. something.
more interesting lordship that this incident happened somewhere like last part of December, and this they have mutually settled the lordship like 20 days lordship after that, the 20th of January.
Yeah,
In short time they have settled
immediately
lordship.
after that.
Yes, lordship. That means lordship they have lordship mutually settled lordship, and they have no other grievances.
And if the proceedings go on, the animosity will increase.
Yes, lordship. That's the point,
Unnecessary.
lordship. Yes, lordship.
Because one person will accuse another because of
Yes,
you. I am
lordship.
going
Then
to the
third
court.
person will come, and that will only
That will not help the purpose and object.
Yes, lordship.
And like which has been the principles which has been laid by the Supreme Court. In many other cases, now we have only placed.
Yes, lordship.
So if this goes on, that is not going to help.
Only lordship the court
It's a
timing of
dispute.
yes,
It's a
sir.
private dispute.
Yes, lordship.
And I'll dispose it off.
Yes, lordship.
Right. Take down. Third, Mr.
J. Sring.
V.
J. Sring.
Mr. J. Sring, learning counsel for the petitioner, also heard. Ms. L. Hage, learned APP at the state of Arunachal Pradesh. This instant application under section 528 of BNSS 2023, filed jointly filed by the petitioners filed by the petitioners praying for quashing and setting aside of the FIR Sangram PS case number 012025 dated 1/1/2025, registered under section 117 bracket 2 bracket complete stroke 74 of Bharatiya Nyaya Sanhita in bracket BNS bracket complete, the charge sheet number 2 of 2025 dated 9/4/2025, and the whole consequential criminal proceeding pending before the learned judicial magistrate first class Koloriang, district Kurung Kume. There is GR case number 2 of 2025 arising out of the said aforesaid FI. The brief facts of the case are that the petitioners are an indigenous tribe. The petitioners belong to an indigenous tribe of Arunachal Pradesh, namely Mishi community, and both are permanent resident of village Sinyik Koyar Pagba, PONPS Sangram district, district Kurung Kame. Both the petitioner number 1 and petitioner number 2 are in fact relatives by way of being in a in-laws relationship. They stay in the same village in neighboring lands. Full stop. However, on 30/12/2024, the complaint spoke FIR was lodged by the petitioner number 1, that is MRS Tai Yape, before the officer in charge, Sangram Police Station, Kurumkume District, Arunachal Pradesh, wherein she had alleged that one Sri Tai Kanyang has attempted to murder her on the morning of 29/12/2024. She also alleged that to Tai Kanyang, both of you sit down. Tai Kanyang, the accused, had criminally intimidated her of dire consequences. It was alleged that the accused person tried to kill her using a machete. He also alleged that she was physically assaulted by nabbing her hair as well as beating her on the face brutally by the accused person, due to which she suffered grievous injuries. He further submitted, he further alleged that she was a widow and helpless, and without having any option, she had approached the police authorities to take proper action in the matter. You said you filed an application before the police.
Yes, Your Honor.
Where is that?
Annexure number 4, Your Honor.
Annexure number 4.
Yes, page number 38.
Page
38.
38. To be seen from the records that has been submitted along with this application, that the incident allegedly occurred on 30/12/2024, and very soon thereafter, on 26/1/2024, a joint request was made by the petition number 1 and 2, that is the victim and the accused, before the officer in charge, Sangram Police Station, Sangram, requesting non-pursuance of the matter, stating very clearly that the dispute between the parties has already been amicably resolved and the informant, that is petitioner number 1, wish to withdraw the complaint against the accused person, and she was not at all willing to pursue the case further. After the investigation into the matter, a charge sheet was filed on 9/4/2025, whereby the accused person, that is petitioner number 2, has been charged under section 74 of BNS and section 1152 of BNS. What did you write? The charge sheet was filed under 74, 115 bracket 2 . One second. Yes, section 74 stroke 115 to BNS were framed against the accused person. And presently, the case is at the stage of records.
Appearance.
Accordingly, the deposition hasn't started yet.
Not start.
When is the next day?
Your Lordship, it is yet to confirm since it was listed on yesterday, Your Lordship.
The charge sheet has been filed, and presently the case is at the stage of appearance of the accused person.
Yes.
Full stop. The learned counsel appearing for the petitioner submits that the parties have filed this present application for quashing the proceeding, for setting aside and quashing the proceeding before the learned CGM, learned JMFC,
Following.
so and so, under section under section 528 of BNSS 2023, as 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 the parties have already settled their dispute, which was existed at a point of time. He further submits that both the parties reside nearby and they are relatives, and they do not carry any animosity any longer. The incident which occurred was purely out of some misunderstanding. Misunderstanding about misunderstanding for the allegation of, what was the cattle, something was there, no?
Yes,
What was the incident?
Destroying of cultivation land
Ah,
by their kettles.
allegation of destruction of the agricultural field of the accused, the agricultural field of the informant by the accused person.
By agricultural land of the accused.
Agricultural land of the accused was destroyed by the cattle.
the kettle of
Of
petitioner number one.
This is number one.
Yes.
Because the allegation, because of the allegation that the agricultural field of the accused person, that is petitioner number 2, had been destroyed by the cattle belonging to petitioner number 1, that is the informant. He submits the issue was very small, and at the heat of the moment, a quarrel took place, and thereby the informant was heard, and therefore the FIR was lost by the informant. He submits that on perusal of the medical report, also it reveals that the injury that was suffered by the informant was of very minor nature. He further submits that though an application for non-pursuance, application for requesting not to pursue, that is filed by the accused as well as by the informant as well as the accused, was not considered by the police authorities even though the application was filed much before that charge sheet that had been filed in the same case. He submits that a mutual agreement did, a mutual settlement did,
Page 39.
is also executed by both the parties on 20th January 2025, which also is an evidence clearly before this court that the parties have mutually settled the matter, and the informant, petitioner number 2, doesn't have any displeasure grievance towards the second party, towards the accused person, petitioner number 2, regarding the incident occurred. Incident was occurred on when? 30/12/2024.
29. 29/12/2024.
29/12. When is the FIR filed? Okay. Occurred on 30/12/2024.
Incident was on 29th,
29th.
Lordship, and the
FIR
FIR
was
was
on
on next
30.
day. 30.
Okay. Then we write 29. Okay. Yeah, yeah. He also submits that parties agree to withdraw the case, like Sangram PS case number 1/2025, and thereby not to go ahead with further proceedings in the matter. He submits that the learned counsel for the petitioner submits that no purpose at this stage would be served if the proceedings before the learned JFMC if allowed to go ahead. The submits that's only submitted. In view of are you citing any case? No.
Yes, Your Lordship. There's two cases here.
First, next one, yes.
And another case, Your Lordship, this. Kapil Gupta.
In support of his arguments. Last line क्या लिखा? What he have written? Read it properly. What have you written? Held to be allowed. Is he allowed to go ahead? Is allowed to go ahead. In view of the opposite, he submits that the instant application may be allowed by this court. In support of his arguments, the learned counsel has submitted the case of the state of Madhya Pradesh versus Lakshmi Narayan and others, reported in 2019 Supreme bracket SC 246. As well as the case of Kapil Gupta versus State of NCP of Delhi and another, reported in 2022 Supreme bracket SC 1108. On the strength of the principles laid down in the aforesaid two cases, wherein the Honorable Apex Court which para this Lakshmi Narayan, which para was there?
Paragraph 9.3. It is at page number 6.
Nine 9.3 is a long paragraph.
Yes, Your Lordship. From there onwards, 29, 29.1 and 29.2, 29.3, 4 and 5.
Wherein the Apex Court has held that while exercising the powers under 528, the High Court is required to examine as to whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal cases. And in this case, which paragraph?
Paragraph number 13, 14, and 16.
Paragraph 13, 14, and
16.
this cost basis ratio is not applicable to it.
Your Honor, it referred to paragraph number 14, which states that when the case is at the stage of initial stage, that the court can invoke the power.
It's a delayed kind of, if it is filed at very delayed charges. In that case, there is no delay or something.
Yes, Your Honor. But it's talk about
Stage of proceedings, it has been observed that if application is made at a dilated stage, wherein the evidence has been laid and the matter is at a stage of argument or judgment, the court should be slow to exercise how it is applicable to your case.
the last line, like, however, if such application met at this
Initial stage for commencement of trial, that the said factor will weigh with the court in exercising its power. But this is not a, I mean, this is not a very delayed stage, this has been done. These are, the incident occurred in 2024.
Okay.
So I will not refer to this.
Okay,
case.
okay.
The other case you cut down, no? That Lakshmi Narayan case, you keep the principal laid down, I have stated. What have you written? Has relied on the case of as well as you cut, wherein the apex court. No, Kapil Gupta, you cut, that's what I said. You cut reported to make it a aforesaid case. Okay. Then complete the paragraph. Paragraph is complete, no? You missed some words. What you read it again. Okay, this is the I will give that later. We'll give it from the case. Also heard MSL Hage, Planet FEP, appearing for the respondent state. She submits that. She fairly submits that the issue and the incident occurred in the instant case may have been a mistake or misunderstanding between the parties. Right? Misunderstanding between the parties. She also submits that the parties involved our neighbors and villagers and illiterate villagers. She submits that the on perusal of the charge sheet and the medical report also disclose that the injury suffered by the informant was of not very serious nature. She clearly submits that looking into the factual metrics of the instant case, as well as the present status, as well as the relationship between the accused and the person and the informant. No purpose, no justice will be served if the proceeding lying before the court of JFMC. What was that? To go on. She fairly submits that this kind of incident usually occurs in villages, and if the proceeding is allowed to go on, the relationship which is prevailing at present between the parties may go to a different angle and go to a different angle, and that will actually not serve any purpose.
What about the look after the statement of all the parties, Lordship? Their statement also been recorded, Lordship. Here also, Lordship, it is stated, Lordship, the eyewitness also stated that both are, Lordship, they engage in the fighting, and see the complainant, Lordship, that she fell down, Lordship, by own, Lordship. That means, Lordship, there's no Lordship.
She also submits that as far as
all the statement
as far as the statements recorded by the police of the villagers,
yes, Lordship. The
it is more or less apparent that actually the informant fell down of her own,
yes, Lordship.
rather than the accused hitting her.
Yes, Lordship.
In view of the aforesaid, she submits that she fairly submits that she will not have any objection in allowing this instant joint application
For the ends of justice also.
joint application for the ends of justice. I have heard what the parties consider the materials which have been brought on record in this application, as well as the case law that has been cited by the counsel for the petitioner. After considering the materials, this court is of the opinion that Supreme Court, that Honorable Apex Court has time and again held that in certain cases wherein the chances of conviction of the accused person is very remote and bleak, as well as allowing of the proceeding to go ahead in the trial court may not actually serve any justice. Rather, it will cause undue hardship to the parties involved in some trivial matters. This court finds strength in the argument made by the learned counsel for the petitioner while submitting the case law, that is state of Madhya Pradesh, that is Lakshmi Narayanan Shukla, wherein also the Honorable Apex Court has laid down the principles to be followed by the High Court while hearing a petition under 528 of BNSS. A paragraph from the aforesaid case, that is 29.5, is extracted herein below, is reproduced herein below. This paragraph I'll give them, which has already been which has already been cited by the counsel for the petition. Taking into account all the material, facts in entirety, this court with the opinion that the ends of justice will be served in setting aside and quashing the proceeding pending before UFMC so and so. Therefore, this instant petition is disposed of as allowed.
Highly obliged.
But learned APP, I will write one thing that like both of you agreed for disposal of the matter at the motion stages.
No, sir.
That I like.
Yes, ma'am.
Both of you agree. Okay? That will I need this one.
Item number 11.
May please, ma'am. My lord, here I'm putting to challenge the order of the.
So there was some objection to be filed by respondent number 2, which is in the
My lord,
respondent. Who is appearing for respondent
My
number 2?
I'm appearing for a respondent.
We have not filed the objection.
My lord, I have not filed the objection, my lord. So, my lord, I filed it, my lord, there is not very necessary to filing the objection, my lord. So, if the matter, if petitioner is ready to dispose of the matter, my lord, I'm ready for oral submission.
You are for the informant. You are for whom?
the informant.
Informant respondent number 2. Of course, my lord, I admit that on the last occasion, I took the time for filing of the reply, my lord. So, my lord, after go through the record, my lord, I find it's not very necessary, my lord. In case of the, my lord, quashing and the CRPC.
Okay.
My lord, here I'm putting to challenge the order passed by the additional session judge in a revision under his revisionary jurisdiction, whereby he set aside the order of the Chief Judicial Magistrate and directed the Chief CGM, the Projo, to frame charges against me and to conduct the trial. Well, facts leading to this present petition, my lord, is that in the month of January 2022, there was a kabang, my lord, between the petitioners herein and the respondent number 2 regarding a plot of land, regarding certain area, my lord. The petitioners herein,
You are Mr. Duge Supriyo.
yes, ma'am.
Yes, yes.
My lord, that there was a kaba, my lord, between the respondent number 2 and the petitioners, ma'am. Regarding, my lord, kaba, my lord, local kaba was there between this respondent number 2 and the petitioners, ma'am, in the month of January 2022. There, ma'am, regarding certain area, ma'am. Initially,
Some disputed land.
yes, disputed land, ma'am.
The village.
Yes, ma'am. What happened was that no one claimed ownership as such, but since it's located in the China border, some army establishments were to be created. And when the issue of compensation money came up, this ownership issue came up. Now on 28th and 29th of January 2020,
That land has been already acquired.
acquired, my lord, that
Land has been already acquired.
acquired.
Now the issue is like the ownership.
Issue is ownership, my lord. That also has now been, I've been informed that it has also been decided, my lord. Subsequent to, there was a civil suit also, my lord, between the petitioners.
Then what happened to the civil suit?
Civil suit, I've been made to inform that it has been decreed in favor of the respondent, private respondent, my lord. Yes.
So there was a civil suit pending regarding this issue also.
That was
See, there was a dispute, then something happened and FIR was filed.
my lord.
Correct.
Ma'am.
But between the parties, there was a civil suit also lying there.
A civil suit was there, ma'am. Civil suit was also there. Well, again, there was
You are the accused or you are the
accused. I'm the
You are the accused.
accused. I'm the accused.
Okay.
Now, my lord, in that kaba, my lord, no settlement could be arrived to, my lord. And I was informed by the PI, my lord, that PI is the political interpreter, my lord, who was supervising the kaba, my lord. Informed that this respondent number 2, they were willing to offer me certain area, my lord, and compensation can be divided in that manner, my lord. But we denied because we wanted the entire area, and likewise the respondent number 2 also wanted the entire area. So no settlement was arrived to.
No settlement was arrived.
Yes, ma'am.
But parties went to the civil court and civil court decided the matter.
Yes, that was subsequent, my lord. Yes. Now, my lord, against that, my lord, kaba, my lord, the respondent number 2 went on appeal, man. Went on appeal, man. So
Before whom?
before the district judgment,
Hmm?
district judgment,
CK.
district judgment. As per the Arunachal Pradesh Civil Courts Act, my lord, that appeal provision was
The
there.
incident happened when?
2022, man.
After
20.
coming of the civil court.
Civil Courts Act. Now, in that kaba, my lord, we filed an objection saying that there has been no settlement. So there is no appealable cause of action, man. There is no cause of action for any appeal, man. And there, my lord, I annexed certain document, man, saying that, of course, I drafted it, and I took the signature of the Gaon Buras, my lord. 4 Gaon Buras, I took their thumb impression. Of course, they cannot read, my lord. I told them that this document says the Kaba has not been able to decide. There has been no settlement. That we said, man. And we filed it, my lord, along with our IA, saying that there has been no settlement, so there is no scope of any appeal. So, my lord, I will take your lordship to
No, see, I mean, it seems there are some disputed question of facts. Where is your no. Mr. Yes, maybe there are some. It seems like there are some factual disputes.
No,
What he said.
so far, my lord, always so far.
No, no. Why I'm saying so is that if there are some factual, differences
Land dispute.
and dispute, there are some factual disputes.
Factual dispute.
Differences. Then if you do not file an affidavit, then how the matter will be executed?
My lord.
My lord, my submission would be, my lord,
On the basis of oral submission, whether it can be adjudicated, because if there are some disputed facts.
My lord, regarding the land, my lord, as such, no, this is only regarding to one document I filed before the court.
There was a KEBA.
Yes, ma'am.
The KEBA, you have filed an application.
Ma'am.
Then stating that there was no settlement.
Ma'am.
Now, against that, they have come for an appeal.
No, my lord, that document which I filed before the district judge, my lord, against taking the, for that document only they have filed the FIR. Rest there's no dispute as such.
For the document, they have filed an FIR.
Yes. That's what I was trying to show your lordship, the document itself, my lord. They have said that I have forced and
You have forced the document and left
Yes.
it to the district judge.
yes, that is what basically the FIR says, ma'am. And now I have been charge sheeted under 420, 468 and 471 of the IPC, ma'am. Whereas, my lord knows 420 is for there has to be some transfer of property, ma'am. 468 is for forgery for the purpose of cheating, ma'am. And 471 is for the using a forged document as genuine, ma'am. Nothing, my lord, that doesn't fall under any of the category, ma'am.
Now, against the civil suit, I mean, which has gone in his favor,
My lord.
have you filed anything?
No, my lord, no, ma'am. Nothing.
You haven't filed anything.
No, ma'am.
What do you mean?
Civil side, it's over. Only the criminal thing remains now.
So you have accepted whatever the verdict has given.
I have accepted. It seems.
Now, what remains, Mr.
Mr. Modi.
No, ma'am.
What remains there? To this
Civil, this criminal portion is remain.
Yeah, correct. I mean, see, there was some allegation that he has forced it. And on the basis of that, we have filed FIR. Now the land is land is given to you. Now what remains? Is there anything remains against him?
Of course, my
And
lord.
they haven't gone for appeal also.
What, my lord, what will be confined with me, my lord, is, my lord, before that. Now the epicenter is pertaining to the Nacho PS case number 1. Nacho PS case number 1 is filed by me, alleging that you have forged the document and thereby you have produced before the authority. That was the case. And accordingly, it was registered under 420, 468 and 470 IPC before the amendments of the new law. So, my contention is that despite the meeting was not settled, that is undisputed. In the meeting, my lord, the customary court. In the customary court, we were there, but despite that, there was no conclusion. But later on, they have drafted a one purported minute of meeting, thereby obtained a signature from the, my lord, GBs, Gamburas of the villagers. And where in that portion, that decision said that 15 acres of the land was allotted by me to in favor of them. That is the main crux that, my lord, since I have never permitted, I have never allowed. Therefore, that document was forged one. This is not the case that, my lord, the term impression of the Gambura has been forged. This is the case that the forgery has been made despite of the KEBA decision, that is the customary court.
And these signatures are like the communication.
My lord.
Those were procured. Those are of those, people, those
GBs.
who were there, GDs who were there,
Ga-
GDs who were there. In the,
Yes, Gamburas were there.
Gamburas.
They admitted, they have put. And my case is not that they have forgery, they have forged this signature and the thumb impression of the Gamburas. my case is that the decision was you are not allowed to draft the decision, because once the customary court is sitting, the trial was there, but despite that there was no decision. The decision.
I got it. Like your only allegation is that though there was no settlement, they have forged the document procuring those on the form. They forged the signatures. Signature communication of the Gambras of the Tekeba.
Of the Tekeba.
And thereby they claim that they have been allotted certain portion of land.
Exactly.
Right.
Exactly.
Yeah, I understood that.
Yes.
Now tell me. See now, this is of course they have the allegation is the forgery and fraud is there. Now, since you have gone to the civil court, parties have gone to the civil court, and civil court has decided the matter.
Malad.
So it was basically a civil dispute from where this thing has happened. Right. Now it has been decreed in favor of you, the civil suit. Right. Now what remains in the matter?
So, my lord, to that extent, my lord, I have agreed with the lordship that to this extent, now nothing remains. But still, my lord, one question is that whether the action of the respondent by drafting themselves, by bordering the decision of the blessed is not liable to be, my lord, prosecuted. And in this regard, my lord, my submission would be, my lord, especially in the state of Arunachal Pradesh, this is going on. This is the common thing, because the Gamburas are illiterate. Therefore, after taking certain decision, they live with the decision, and the other person has decided.
I understood. I understood your point.
My lord.
What about the learned APP? What is your? I'll hear you. Huh? I'll hear you. I'm just asking you there.
The lordship is, as per my understanding, your lordship, there is nothing as to forgery or use of forged document. Otherwise, because the document which was the purported document of the Kaba, your lordship, it was submitted before the court, your lordship. If that document is being in dispute, your lordship, it would, and if the allegation is that that document was not made by the Kaba members, your lordship.
That issue was raised before the game or not?
Before the court,
Before the civil court?
civil court, your lordship. If that is the case, that would amount to perjury, your lordship. And they can, as per the 340, they can make a complaint before the magistrate that the documents submitted before the court is, has been, it's a...
Yeah, it's a false document.
False
document. They suppressed it and they are submitting the.
Yes, that would be the case. But as per the sections, that is cheating, forgery, and use of forged documents, your lordship. As per my understanding, your lordship, these sections does not attract in this case, your lordship.
Now, what is this case there?
My lord, the CGM, my lord, the learned CGM discharged the petitioners. Against that, they have gone to revision before the sessions. And that order of the CGM was set aside by the session judge and directed for framing the charges against the petitioner. Now, after against that order, we have come here, my lord. This honorable court was pleased to stay that, and then as of now, my lord, nothing has proceeded, my lord.
Where is the stay order?
It's at 5/9/2024.
Yes.
Proceed, my lord.
Yes.
My lord may come to page 14, my lord. Annexure 1.
14.
Yes, 1/4, Annexure 1. This is, my lord, the appeal,
filed by them.
yes, appeal filed by the respondent, my lord, even though there was no settlement. Now, my lord, if your lordship would come to page 31, my lord, and 31 is the handwritten, my lord. 34 is the typed copy, my lord. This is a part of their petition, my lord. Page
They
30,
have filed this.
appeal, my lord, against the Kaba order, my lord. The Kaba did not pass any order because there was no settlement. Now, page 34, my lord. This is part of their appeal only, my lord.
This is filed against the KEBA order.
Yes, my lord. Page 34 is
Against the KEBA order, wherein you are submitting that there was no decision taken.
no decision.
KEBA order, there was no decision. So they have come before the district court
District court, my lord.
against this KEBA order.
Yes, my lord.
KEBA order is at page,
There is no order as such, my lord, because there was no settlement.
no settlement. There,
Yes, ma'am.
there was no resolution, nothing.
Nothing, my lord. So this is page 34 is a repeat.
That KEBA was sitting, KEBA sat on the date.
My lord.
Is there anything on record?
Yes, my lord. That page 34 is the report, my lord.
Page 34.
Yes, page 34 is the typed copy, my lord. It starts from page 31, my lord.
Oh, this is what I was
Yes,
telling you,
yes.
that there should be some record.
Yes,
no?
there's a report, my lord, of course.
So there is a report from the KEBA,
Yes,
and this is at page 34.
34 is a typed copy, yes, ma'am. This is by the person who was.
So you come to the concluding part, the KEBA.
Last part, my lord. This
It was found that the trial has been.
it is found that trial has been done through the relatives to solve this case between Singming is the petitioner, my lord, and Mara is the respondent number 2, my lord. Recently, hence, after considering the age-old cordial relationship between both family of Mara and Singming, and also regarding the initiatives taken by the relatives of both the family to solve this issue case, we, the bench of judges, have appealed and advised both the party as below. 1. The land compensation against 15 acres out of 19 acres to be received from Indian Army Defense may be shared to Singming family in order to maintain their relationship. 2. The whole land of Galemo with rest of land compensation amounts should be under the right and possession of Thai Mara family.
Is there any dispute in this document?
No, this is their document. In fact,
This is their document.
Yes.
Then KEBA has taken a decision.
No, they suggested, but of course, even after this, both the parties did not agree, madam. This is a report.
There is nothing on it.
Ma'am.
You agree or not? See, once the
Right.
court passes an order,
My lord.
KEBA is like a village court. Is
My
it
lord.
customary?
No.
Now KEBA has passed an order. Now you agree or do not agree to that. That doesn't matter.
Of course, madam. This,
Then,
my lord.
then in that situation, they have come to the district court.
No, my lord. Sorry to interrupt, my lord. This is by the PI, my lord. PI has no role in the KEBA. He was just preparing the minutes, my lord. PI is the
It was not
political.
given by the KEBA.
No, my lord.
Huh?
This is by the political interpreter, my lord, who was just, my lord, facilitating, my lord. Page 33 is the person, my lord. PI limiting. He is not a person, my lord. Authorized,
So
my lord.
KEBA members, they haven't signed it.
Yes, my lord, because there was no settlement. This, he has only prepared it only for the purpose because these PIs, my lord, they are government employees, my lord, and they report to the circle officers, etc., my lord. So maybe for that purpose, they have prepared this report, my lord.
No. So this PI is a government employee.
Employee, government.
What is the full
Political interpreter, my lord.
political interpreter?
Interpreter, yes.
So they are government employees.
They are government employee.
And they remain present in all these KEBAs.
Not necessarily, but so in some places, they have no, otherwise they have no jurisdiction to conduct any KEBA or supervise any KEBA.
But if there is a KEBA happens,
Yes,
and there is some order from the KEBA,
yes.
and this is being reported by them to the DC, is this their function?
That is what usually they are doing, man. Otherwise, but the KEBA decision has to be signed or thumb impression, whatever. It has to be done by the Gaon Buras, man, the village authorities.
So this is not properly
Yes,
executed.
yes, man.
This minutes of meeting or whatever,
My lord,
or the report,
my lord.
that is not properly
Mm.
done as per your customary law.
Yes, my lord. Now, my lord, this page 35 is my IA, my lord, in that appeal, man.
Wait, now this has happened, then they have challenged this.
Yes, madam.
They
They
have
have-
challenged this by filing this.
Yes,
The BSR civil appeal,
civil appeal, yes.
annexing this document.
Yes, madam.
And in that proceeding,
Yes, madam.
we have filed their objection.
Yes, madam. I filed an IA that is at page 35, madam.
We have filed an IA.
Yes, madam.
Yes. IA for what?
It is page 35, my lord. It's praying for the dismissal of appeal, ma'am.
Okay.
Basically, in this, what we have said is that there was no decision, my lord. And for that only, my lord, for that purpose, my lord, I procured a document,
See,
ma'am,
this is a customary court proceeding,
my lord.
which has been filed before the civil judge, district court.
My lord.
Correct. I
Yes.
mean, whether CPC is applicable there.
My lord, when, of course, your lordship knows, my lord, when the, is said, because there are two options when an appeal is filed before the district judge, my lord. Now, it has further been amended, my lord. It is now before the civil judges, my lord.
Correct.
Yes, ma'am.
Earlier it was before the deceased.
District judgment.
Earlier it was before the district judge.
After the coming of this act, my lord, 2021 act, it was the district judge. Subsequently, it has been amended again, my lord. Now it may lie to the civil judge junior division also and senior division also. Civil judge senior division.
Civil judge.
Yes.
And like, what will be the proceeding? How it will be
Yes,
conducted?
ma'am. Now, when it is filed, ma'am, there are two options before the civil judge. One, he can try it, continue it as an appeal, madam, or the learned civil judge may try to decide to try de novo. Now, when de novo it's
So
tried,
that is there in your yourself as frontier rules.
yes, a civil court second. When they and there's a judgment of this court also, my lord. When since your lordship knows that appeal is a continuation, my lord, of the original proceedings,
So if it is a continuation,
then
it will have to be conducted as per the customary law.
yes, my lord, then civil procedure, my lord,
But
CPC
he'll have
is
to take a decision. But he'll have to take a decision whether the appeal will go as per the customary law or as per the civil procedure
Yes.
de novo civil court
Yes.
civil court proceeding.
my lord.
So whether it has been done here,
No, my lord. Here, after we file this, my lord, that I will take
that
your
you have filed under CPC.
yes, my lord.
So that means like you are presuming that the court will go ahead with as per CPC.
Yes, that it has been filed. Yes, my lord. It seems so, my lord. Under 41 only they filed, my lord. Now your lordship may come to page 47, man.
Page 47.
Yes, ma'am. Because of which this FIR has been lodged against me, ma'am.
Page 47.
Yes.
Yeah.
By this, we just wanted to bring it before the court, my lord, before the district judge, that there was no settlement. And your lordship has already seen the report of the PI, my lord. Now this we have prepared.
With reference to circle officer number so and so, dated so and so.
Or-
What is this? Circle officer,
This order number, my lord, to conduct the Kava, my lord. Circle officer has passed some order of 13 January 2022.
Like,
to
is,
hold
is,
the-
is it a pre-requirement? I mean, like to have a KEBA, the circle officer has to permit it.
No, my lord, they are empowered to facilitate, my lord, because the Gaon Buras, they do not have any office as such, my lord. So mostly now also, my lord, the circle officers, they facilitate by passing some orders that you hold Kaba so and so. Before the Gaon Buras, they send it, my lord. Dated limiting the 13 January 2022, local Kabang or local land dispute of Gelemo area was discussed at Orak village on 27 to 28 January 2022 under limiting circle. After 2 days of local Kabang discussion, Sri Taimara, the respondent, offered 15 acres of land to Singming family, the petitioner. But Singming family totally refused the said land offered by Sri Taimara. Singming family people claimed 100% Gelemo area as its own land. Down below, my lord. The local Kaba was not finalized settled. In the end, and all Kabang functionaries under chairman of Sri Tapur Baki, PI, circle limiting,
But how
circle
can he
officer.
is the chairman?
My lord. Tapur Baki, that person, your
He
lordship.
is the PI.
Yes, ma'am.
But PI, how can the PI be the chairman of the?
No, he cannot be. He cannot be, of course, ma'am. He cannot be, ma'am. That procedure was, of course, not as per, not.
But this is your document.
Yes, this is document. What I'm saying is that here is that the Kaba is no settlement, basically. Your lordship has seen the report of the PI.
But
It's
their allegation is not about that.
ma'am.
Their allegation is that these thumb impressions,
No, ma'am.
those are not these people of these people.
No, ma'am.
Is it your allegation?
That part also I'm coming. Investigation has been done, my lord. The statements of
So you, as per you,
yes, ma'am.
that local keba happened,
My lord.
and in the local keba,
My lord.
there was a proposal that some portion of land will be given to him, some portion of land, but the parties did not agree,
Those did not agree.
and nothing happened.
Nothing happened.
And to show that nothing happened that on that particular day,
Yes, ma'am.
you don't have any document. We didn't have any document.
Didn't have.
So you have prepared this document.
Yes, ma'am.
And it took the signature.
Thumb impression. Yes.
You have taken the thumb impression
Yes.
of the people who sat in the cabin.
Yes, ma'am.
That is the thing. That was your purpose.
That is the part, my lord.
Purpose.
Yes, ma'am. That is the
And on the basis of this, now they are saying that no, this thumb impressions have been procured
yes, ma'am.
fraudulently.
My lord.
Procured.
My lord.
This is the first document. This is the first document whereon this thumb impressions are forged.
No, my lord. In the FIR is at page 51, my lord.
Page 51.
51, my lord. Subsequently, my lord, this appeal was withdrawn, my lord. Subsequent to this, my lord, after we filed the application, that civil appeal was withdrawn from the district judge, and they filed a new suit, fresh suit.
This was withdrawn.
Withdrawn.
That appeal from Keba was withdrawn.
Yes, my lord. That is at page 48, my lord.
So your purpose fulfilled.
Fulfilled, my lord. That part fulfilled, my lord.
Fulfilled. So they withdrew the
Appeal, my lord.
appeal from Keba.
Yes, my lord.
Keba, but filed another civil suit.
My lord.
But filed another. What they have filed?
The fresh suit, title suit they filed, my
They
lord.
have title suit before whom?
Before the Civil Judge Senior Division, Dapurisha.
Correct. Then
Now, after the withdrawal of this appeal, my lord, then this FIR was lost, which is at page 51, my lord.
Page 51.
51. 5-1, my lord. Annexer 5, my lord. To the officer in charge, police station Nacho, subject, complaint against Nasu Singming, Tapong Singming, so and so, Tanam Singming, so and so, against the petitioner.
You read the contents.
My lord. Sir, it is bring to your kind notice that there was a civil appeal case was going on at Additional District Judge Basar, which is marked as number 1 of 2022 in between Taimara versus Talom Singming. Case was fixed on 6th May 2022 for written statement from the defendant. That is Talom Singming. The defendant has filed an interlocutory application. I received it in his application. He annexed one document in page 14 and annexer B, which name and style is Local Kabang Discussion Statement. In this Kabang records, 5 GB's name were recorded. Sri Taumara, GB, Tamar Mara, GB, Tadongoju, GB, Tamar Nilo, GB, Tangarai, GB. Out of 5 GBs, 4 GBs were gave their thumb impression, which state that Sri Taimara offered 15 acres of land to Singming family, but Singming family totally refused the said land offered by Taimara. Singming people claimed 100% Gelome area as its own land. So after I receiving the application from Talong Singming, I inquired to Sri Tangarai GB and other GBs. They clearly said that it type copy of paper was brought by Sri Tasu Singming and Tanam Singming. Asked them to sign on the paper, told them that 27-28 January 2028, the Kaba was not finalized. And then the Tadong Ujo, Tamar Mara GBs, Tangarai were put their thumb impression. But the statement of Sri Taimara offered 15 acres of land to Singming family is totally wrong and misguided them. So I obtained the certificates from all the GBs who were put the term impression, and they clarified that they never said that Thai Mara has offered 15 acres of land to Singming family. Under this fact stated above, the acts of Tasu Singming and Tannam Singming is nothing but forgery of valuable security, fabricating false evidence from the Kabang authority that is GBs and wanted to use this false statement before the court against me, which is punishable under section so and so, so and so. In the FIR also, he is saying the GBs put their signature, but they did not say, as per the content, that the respondent offered me 15 acres of land. That was not informed to them. That is what the FIR says, ma'am. It's not the case that.
You forced this.
Yes. In the FIR itself is saying that 4 GBs, they admitted putting their thumb impression on the paper. And I told them that this is a document where I have said there is no Kava settlement. That is a fact also, ma'am. Your lordship has seen.
Like, they said that they never afford this 15 acres of land.
Yes, that part they are saying. That is why this FIR was filed. And subsequently, my lord, if the charge sheet also is in the statement recorded also, my lord, 161.
Charge sheet, let us see the charge sheet. Page 53.
55, my lord, it starts at page 55. Marital.
Yes, 420, 468, 471, and 34
Right.
initially.
Right.
When the charge sheet was filed. Then what were the charges framed against you ultimately by the trial court?
Well, but the CGM, my lord, discharged, my lord.
Hmm?
CGM
discharge.
discharged, my lord. And the impugn order, my lord, the order of the
CGM's order,
CGM's order is at page 85, my lord.
page 85.
My lord.
Yes, so much page 85.
Page 85. Otherwise, my lord, in the charge sheet also, my lord, the statement of the GB is also recorded. They say we have put the signature, everything, FSL also.
See, now, putting of the signature is not an issue.
My lord,
The issue is only that you have misrepresented.
yes, statement,
Misrepresented them while procuring the signatures.
my lord. That
Come to page 86. Second paragraph, third paragraph.
my lord.
Effectively second paragraph only. I have also gone through the local KEVA discussion wherein it is mentioned that on 27-20 January, local KEVA was conducted for a land dispute and so and so. After 2 days of the KEVA,
My lord.
Time Era offered 15 acres of land to the Singling family, but Singling family refused the offer by the Time Era and claimed 100% Glemo area as their land.
Right.
From where it has come?
This is, my lord, the document, my lord.
Hmm?
This is my document that I have.
After 2 days, that document that you have made. He's mentioning about this document only. See, this fact after 2 days of the
Oh, my lord, my lord, my lord. Then not to, that part, not,
Huh?
not me. The document, local kava discussion.
No, see, here the finding he has recorded is that I have gone through the KEBA,
My lord,
was conducted so and so. After 2 days of the KEBA,
my lord.
Time Era offered 15 acres of land
Right.
to Singling family. But Singling family refused the offer by Time Era and claiming 100% of Glemo area.
Right.
So this finding, this has come from where?
This he is referring to my document, my lord, that I have
The
said.
document that you have produced before the court.
Before the court, my lord. Because we have said that 2 days there was a kava, my lord, 27 and
But he said after 2 days. Okay,
Right.
got it. Okay. Okay, after this, you have gone for appeal.
yes, after this, the respond number 2 went for revision, man.
Ah.
It is at the
That revision petition is at page 88.
88 and the order of the
Ah.
session judge is at 101, page 101. 101. Now, in this order, my lord, what the session judge has said, during the time of framing of charge,
Hmm.
The issue regarding the cheating and these things, my lord, it cannot be taken. It has to be proved during the trial. And in that line, my lord, he has directed for framing of charge against the petitioners under 420, 468, and 471. It's at 110, starting at 110, my lord, page 110, my lord. Just I'll read two paragraphs, my lord.
Yes.
Paragraph 16, my lord. I have relied the para 23 of the said judgment of the revisioner, quoting out the decision previously made by the Honorable Supreme Court India in the case of state of so and so of para 29, which is produced as under. At this stage, probative value of the materials has to be gone into, and the court is not expected to go deep into the matter and hold that the materials would not warrant the conviction. In our opinion, what needs to be considered is whether there is a ground for presuming that the offense has been committed and not whether a ground for convicting the accused has been made out. To put it differently, if the court thinks that the accused might have committed the offense on the basis of the materials on records on its probative value, it can frame the charge. Though for conviction, the court has to come to conclusion that the accused has committed the offense. The law does not permit a mini trial at this stage. Next operative portion, ma'am. In view of the above findings, the revision is allowed.
Wrong in this judgment, disorder.
What I'm saying is that now the direct.
Now that the thing has boiled down to one.
Ma'am.
Boiled down to the thing is that whether session court was correct
Ma'am.
in passing this order
Ma'am.
or not. Supreme Court, the Sessions Court has, not Session Court, the district and session judge has stated
Ma'am.
that as far as the document is concerned,
Ma'am.
on the basis of which the FIR was filed.
Ma'am.
So whether that carries any prima facie value or not, probative value or not. And that can be decided, that issue can be decided only when the trial is done, right?
Ma'am.
Now, so you will get the opportunity to defend yourself there.
Ma'am.
So what is your submission on that?
My submission, my lord, that direction has been given to 420, 468, and 471. At least there has to be some material, my lord. Without material, can a charge be framed against me, my lord? My lord knows, my lord, 420 is a cheating and dishonestly inducing delivery of property, my lord. There is no delivery of property here, my lord. My document was saying that no cause of appeal lies as of now. My document said Kaba has not been settled, finalized. Now 420 does not lie, my lord, nothing, my lord. There has been no delivery of
420 is not there then?
no. Then 468, forgery for the purpose of cheating, my lord. There is no forgery, my lord. The FSL report is there, my lord. In fact, the statement of the Gaon Buras are there that we have put our thumb impression, my lord. There is no forgery, my lord. Then 471 is using as genuine a forged document. Using as genuine a forged document, my lord. It is also not the case here, my lord. There has been no delivery of any property, my lord. There is no exchange of any property, my lord.
But there is misrepresentation.
At the best, my lord. But these sections does not attract, my lord. At least there should be something to say that. I agree with this view, my lord. Of course, that there is no quarrel with that law, my lord. That probative value, my lord. The mini trial cannot be mini trial, but can a charge be framed against me without there being any material, my lord?
Which is apparently showing that.
Apparently, yes.
Apparently showing, and like from the statements also.
Yes, my lord.
The documents also apparently showing.
Yes, my lord.
That other than misrepresentation,
my lord.
we have not done anything.
My lord.
But misrepresentation we have done while procuring the signatures.
Signature, yes. And that too, my lord, is based. Your lordship has seen the report of the PI also. They advised, my lord, maybe there was miscommunication, but whatever.
The only thing is that 15 acre or whatever land.
My lord.
That was never there in the document.
Yes, my lord. That part that GBs are. Yes, that I am including. I have said they offered us, but we have not agreed. So the Kaba has not settled. That is what the report is, my lord.
Yes, I got your,
Yes.
I got your,
Yes.
this thing point. Now let me.
There's one another aspect, my lord.
Is
now-
do you have any case laws to cite?
No, my lord, that,
See,
that-
point is on only one thing,
my lord.
is that, while framing the charge sheet, whether the, district and session judge has properly, used their mind
My lord,
and whether properly charge has been framed or not on the basis of the materials on record
my lord,
at that, before the session judge.
my lord.
So now you were saying that on the basis of the materials which
Right.
were, there before the court, these charges could not have been framed
No, my lord, not,
because there was no material
my lord.
for section 420.
Yes,
and other sections
468, 471. There's no forgery, there is no delivery of any property,
any
my lord.
property. So this
That-
this is your argument.
One more aspect, my lord.
Ah.
Another aspect is that what they are claiming is that there is been a false evidence, my lord, before the court, my lord. Basically, what they are saying that
False evidence by way of putting this document.
putting this document. Now, your lordship knows there is a clear bar under section 195, my lord. CRPC, my lord. Now it
What is that?
subsequently is in BNS is 215, my lord. But in CRPC, my lord, section 195, my lord, no court shall take cognizance.
Section
195 CRPC, my lord.
195. Yes, yes.
Yes, my lord. No court shall take cognizance of any offense punishable under any of the following sections of the Indian Penal Code, namely section 193 to 196 and so sections, my lord, which deals with false evidence, my lord. When such offense is alleged to have been committed in or in relation to any proceedings in any court. My lord. So they could not have taken cognizance that this because of this also, due to a clear bar of this, my lord. Then
Come again. What did you say?
no court shall take cognizance, my lord.
Which section you took?
Section 195, my lord. CRPC, my lord.
And BNS is what is that?
BNS it is 215, 215, my lord.
But they're still writing IPC over.
This is IPC, this before the,
What is?
yes. This is 2022, my lord.
Yes, 195 CRPC.
My lord, under the IPC, my lord, regarding false evidence, section 191 to 211, it deals with the false evidence under the IPC, my lord. Now this CRPC under 195 CRPC, my lord. Lordship is there, my lord.
195 CRPC.
Yes. Prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. No court shall take cognizance.
Prosecution for contempt of law, contempt of lawful authority
Yes, ma'am.
of public servants. It's for public servants only.
No, my lord. It is B, my lord, coming to B, my lord.
No,
And
so-
otherwise also then there is a provision under section 340, my lord.
no, how this is applicable 195?
My lord, 195, then 340 is there, my lord. Because
One second.
for offense.
No court shall recognize it as a
Married, 1B, my lord.
Wait a minute. Yes, what is your submission on this?
Yes, my lord. My part is, since they are saying, or lordship is saying, the last part for offences relating to documents given. Now, no court shall take cognizance, and B, my lord, B1, my lord. No court shall take cognizance of an offence punishable under any of the following sections of the IPC, namely sections 193 to 196, both inclusive, 199, 200, 205 to 211, both inclusive, and 221. These all sections,
Which is your section?
well, 191 to 211, my lord, it deals with false evidence before the
False
court.
evidence before the court.
Court, my lord. Documents or false evidence before the court. When such offence is alleged to have been committed in or in relation to any proceeding in any court, except on the complaint in writing of that court or by such officer of the court as that court may authorize in writing in this behalf, or some other court to which that court is subordinate. Basically, your lordship, it is about the false evidence. They are saying that the document which I filed before the district judge, man, it's a false document, man. Now, if it's false document before the court, my lord,
They should have made a complaint.
they should make their complaint, my lord, under section 340, or otherwise, no court shall take cognizance except on the writing of the court, my lord, writing or complaint of the court, my lord. And the procedure, my lord, that was available to them was under section 340, my lord. They could file an application before the court, my
Section
lord.
340 of
CRPC, my lord.
CRPC.
CRPC, my lord. They could approach the court, my lord, district court, my lord, for proceeding against them for perjury.
That they have not done.
They have not done, my lord. They straight away went to the police station, my lord. This section is very clear. There's a clear bar that until and unless in relation to a proceeding before the court, man, when it is about the false evidence before the court, man, that specific complaint has to be made by the in writing of that court only, or by such officer authorized by the court.
No, that is correct. But
Yes,
as far as FIR is concerned, they can always go in and file an FIR.
They can file an FIR, but when it's relating to that court, man,
No, they can file an FIR, but
my lord.
what probably you are trying to say is that while charging while framing of the charge,
My lord.
that aspect should have been taken care of.
Yes, my lord. They could not have taken cognizance itself, man. That is what I'm
But
saying.
that aspect, whether it can be done at the very initial stage or while framing of the charge or after framing of the charge.
Well, that framing of the charge.
While after the framing of the charge, they can always file a petition under section 342 CRPC.
Section 340 CRPC, my lord, they can, the respondent then can file, my lord.
They can.
My lord, but that is a complaint, my lord, basically, my lord. That here it says the court cannot take a cognizance also, my lord. When it is relation to a document or an evidence that I've given in false before in the proceeding before the court, my lord. Until and unless there is a written complaint by the court or any officer authorized by that court, my lord. The facts not disputed, my lord. Facts we are not disputing.
So basically, you are agreed by the cognizance that has been taken.
Yes, cognizance also could not have been taken. That is what I'm. Other than the fact that there's nothing on record, man, nothing to show that these charges are attracted against me. There is also a bar. That is basically my submission on these two counts. Firstly, there is no document. There's nothing on material, no material, my lord, to show that these charges are attracted. And secondly, the court could not have
Do
taken.
you have any judicial pronouncement on this?
That part I have not. No, I have not brought, man.
Why?
I'm sorry, extremely sorry, my lord.
This
But
is a very important matter where some legal issues are involved.
Man.
Correct.
Man.
It's not a very straightforward, straight kind of case. And in this kind of cases, being a young counsel, you should come up with some judicial pronouncement, no? So that we can assess the court properly, and the court can properly do justice.
But
It's
I'm
an important point here, which we have argued. I appreciate that. So for that, we should have come up with some kind of judicial pronouncement.
yes, no, I'm sorry. I'm really sorry about it. But since 195 bar is already there, so
No, 195 bar is. You should have come up with some pronouncement. on this. Now I'll have to look for those.
Otherwise, but I can provide, Madam.
Madam, you can help me out.
I can also provide, but not today, but tomorrow I have some difficulty. By day after tomorrow also I can provide.
After tomorrow.
Or maybe by tomorrow also I can provide to the.
That's all for your argument, or anything else is there?
Basically, that's it, my lord. And as I said, my lord, basically it is about the offense is regarding the affecting the administration of justice only. When I file a wrong document. For that also provision is there under section 340. They can file an application.
And then I understood your point. Now let me hear them. I think PP should come first.
Yes.
Recently, we should come first. You are only an informant, no? But you have become a party.
In fact, as I've already submitted the lottery. So I may just take the lordship to the
Sections,
not sections, the lordship, page number 34, your lordship, Kaba sitting,
page 34.
34, your lordship. As I concede to the submission made by the learned counsel for the petitioner, your lordship. I just,
You concede.
yeah, I concede, your lordship.
So you agree whatever he has submitted.
Yes, your lordship. I'll just clarify some of the issues, your lordship. At page number 34, your lordship will see.
The page 34, yes, I have seen that.
Lordship will see if this was a Kaba order, it would have been written as Kaba order. However, the heading itself says Kaba sitting report. It was a report submitted by the PI, your lordship.
So basically, I mean, though he is not authorized to do it, he has done it.
Yes, report can be submitted by
A report can be submitted by him to the DC.
to the DC.
So he has submitted a report.
Yes,
So there is no problem in
there
this.
is no issue in that, your lordship.
Correct.
At page number 47, your lordship, this is the disputed document, your lordship.
Yes.
Uh,
So compensation has been received for 15 acres only. That 15 acres that which they are talking about.
Yes.
Is that so? The 15 acres.
No, I have not received any complaint.
No, you haven't, but they have received.
They have received everything.
And these 15 acres, like you have written that they wanted to give it to you.
Yes, ma'am. Because, my lord, you'll see the report also, my lord. The PI says we advised the Mara. The only difference is that the PI says we advised the Mara family, and we wrote the Mara family offered us 15 acres. That is the only difference.
Yes.
The only line at page number 47 in dispute is after 2 days of local Kabang decision, Sri Tai Mara offered 50 acres of land to Singmi family, your lordship. This is the only line that is being disputed by this.
Yes, this is the bone of contention.
Yes, your lordship. Now, if I may take your lordship to, I'll just take your lordship to the page number 82, which is the forensic report, your lordship.
Page 82.
82, you know. Four of the signatures that was in the
Those are tallied with the official report.
only one of them tallied. Rest of the 3 could not be distinguished because the specific main given was not enough, your lordship.
So nothing can be presumed from there, and like it was not disputed that like their signatures have been taken.
Taken,
But the only contention is that like, it has been taken by Mr. P.
Yes, your lordship. Now also, your lordship, I'll just point out one of the statement of the Gambura, your lordship.
Yes, yes.
If I may take your lordship to page number 65.
Page 65. Statement have been recorded for all the Gamburas.
All the Gamburas.
All the government.
And whether any accused, what are the statements? You should have shown me this.
Yes, I was coming to that, but your
Anyways, now
Yes.
this is,
I'll just
any allegations against.
I'll just read the second and third paragraph, your lordship. After few months, so and so came to my house at Midanala with local Kaba decision statement paper and asked me to put my thumb impression on it. When I inquired him what this paper is all about, he explained me that paper is a report on unsettled Kabang on land dispute between Taimara and so over Gelomo area, and further told me that the report is to be submitted before ATSJ Basar. This is additional district session judge. Since I'm illiterate and I cannot read or write, so I believe them and put my thumb impression on the said paper. After some more weeks, I came to know from Sri Taimara's family that the report on unsettled Kaba which states that Sri Taimara offered 15 acres of land to Singmai family, but Singmai family refused the said land offered by Sri Taimara. Singmai people claimed 100% of Kilomoy area as its own. This is totally false, and I had no idea about the false report, as Tasu Singmoy only told me that the report is only on unsettled land dispute, but no regard land offered by Sri Taimara. Further, Sri Taimara did not offer any land to Talmoy Singming or Singming people, as he rejected our proposal to spare 15 acres of land. So even the Gamburas admit to the fact that he was explained in terms of that this document that is to be signed is mainly with regard to unsettled report of the Kaba Lordship. However, the extra paragraph, extra sentence that has been reflected even in that document, that the offer of 15 acres was made by the statement of the Gambura, was that it was false, Your Lordship.
Yeah, that is the thing. What basically probably all the Gamburas are saying the same thing, right?
Same thing, same.
They also stated that that this was never discussed. About
Yes.
15-acre land,
The offering of 15
offering of
acres.
15-acre land was never discussed.
However,
That was the thing.
yes. However, coming to the entire case, Your Lordship, will see that there was no forged document. They had signed. There might be a case of
As far as the factual part, I'm clear.
yes.
Now, you argue on the legal issue. What is wrong in that? I mean, now you are conceding to his submission.
Yes.
That's why I'm asking you.
Yes.
The session judge, where did the session judge go wrong?
Yes, Your Lordship. If I may take Your Lordship to page number 107, Your Lordship, this is the impugn order and the points taken by the session judge while directing for
107.
107. Paragraph 10, Your Lordship.
Paragraph
10, Your Lordship.
10. Yes.
If I may read, Your Lordship.
Yes,
Having
please.
heard both the learned counsels and upon perusal of the case records, it's observed that the finding of the learned court below is found to be erroneous for not taking statements of all GBs, namely so and so, into consideration while deciding the case. Had it been taken into consideration, the learned court below would have had the opinion that the contents of the signed Kaba decision produced by the discharge accused after 2 days of Kaba is not explained to the signatory, which is not the factual fact, as decided in Kaba so and so. Therefore, the finding is apparently wrong. Here in this, here, Your Lordship, the learned session court, while
He has concluded on the basis of 161 statement.
161 statement, Your Lordship. However, the only the error that I find in this particular paragraph is that the learned session judge, though he has admitted, though he is taken into consideration the 161 statement, Your Lordship, however, the contents of this signature, that the paragraph that after 2 days is false. He admit to the fact that this was false and it could have been taken considered. It could have been considered by the trial court. However, in this paragraph, he does not state that it was a false misrepresentation. In fact, he had conjointly read them as a forged document. Then, Your Lordship, paragraph 11, Your Lordship.
Yes.
It is also observed that the FSL report and the admitted fact of the signing by the GBs is not an issue in this case. But the learned court below has taken it as a ground for discharging the accused, which is irrelevant to have such opinion, as thereby the impugn order is liable to be interfered with. Your Lordship will see, I'll just pause, Your Lordship. FSL report clearly says that it was the signature of one of the Gambura. Even the Gamburas admit, Your Lordship. However, when the court who has discharged, trial court who has discharged it, Your Lordship, on the basis of the FSL report also, even that report was not the trial court while passing the impugn.
See, I mean, he is saying that learned court below has taken it as a ground for discharging the accused.
Yes.
which is irrelevant.
Yes, Your Lordship. Now, if that is the case, Your Lordship will see that the FSL is a part of the charge sheet, Your Lordship. The allegation is with regard to cheating, forgery of document and forgery, Your Lordship. Now, if those sections are being discussed during framing of charge, Your Lordship, all the documents contained in the charge sheet is to be taken into consideration, Your Lordship. The FSL report is one of a scientific report which states that it was the signature of that particular head Gampura, Your Lordship. So where is the question of that being erroneous and not taking that into consideration?
That is a prima facie looks like there are certain sections which should not have been included.
Yes.
But what do you have anything more to argue on this?
Not particularly on FSL report, Your Lordship. Only that.
Any more paragraphs you want to refer?
Yes, the continuum paragraph, Your Lordship.
12.
11. 11 itself, the continuing paragraph, Your Lordship. As per record, what is the issue in the case is that whether the contents of original Kaba decision was changed by the accused by making a false statement in the alleged forged Kaba decision to the effect that the revisioner has offered 50K. Now, Your Lordship will see that the Sessions Court took the Kaba settlement report as a Kaba decision, and the subsequent document which is in issue, Your Lordship, that as a subsequent false statement of that Kaba, Your Lordship. Now here, neither the Kaba was forged. That was just a report, Your Lordship. And the subsequent document as already even written in the IA of the appeal, Your Lordship, for dismissal of the appeal, previous appeal, Your Lordship. Even then, at that point of time, the applicant clearly stated that that was just for the sake of bringing to the court's notice that the Kaba was unsettled. So there is no question of forging the Kaba order, Your Lordship.
Okay.
Then my last would be with regard to perjury. If that is the case, Your Lordship.
And you submit on this thing. I mean, see, while concluding, the learned session judge has cited this case.
Yes, Your Lordship.
And para 16.
Yes.
And he is talking about the probability value, and like he says that like this can be settled during the trial.
Yes, Lord. Yes, Your Lordship. This citation more particularly speaks about that during the framing of the charge, Your Lordship, the
So what he is saying that the probability value, on the basis of the probability value of the document, he has framed the charge.
Yes.
And later on in the trial, I mean, that can be disputed or whatever, can go either way.
Yes.
But at this stage, he has to look into the document for its probability value, or like whether any discloses any offense or not.
Yes.
Prima facie offense or not.
Yes.
But that will be proved while trial is on. So that is what he is saying. So what is wrong in that?
There is nothing wrong in this, Your Lordship. However, my understanding of the impugn order is that the learned Sessions Court has misunderstood the concept, misunderstood that the Kaba report was a Kaba order, Your Lordship, and the subsequent Kaba statement submitted by the applicant herein that it was an unsettled dispute. He took that as a subsequent purported Kaba.
Got it. I got it. So that's all. And like now, Mr. Modi.
My Lord, since we are meeting for the first time, my Lord, my nature is somewhat shallow in nature, my Lord.
Sorry?
Shallow in nature, my Lord.
No, not a problem, but we don't have
so,
much time.
my Lord, so far I have considered the argument that the argument on the part of the petitioner is, my Lord, that they have to explain because they are the petitioner. And I fail to understand, my Lord, this is on the part of my sister, the PP, while he is coinciding with the submission of the petitioner. But whatever reading out relevant is in my favor. However, my Lord, I will skip whatever, my Lord, I will not touch to the civil nature. Since my case is straightforward, therefore, my Lord, I have nothing more to submit, but I will go with the document what is before the Lordship and before us, my Lord. So first of all, my Lord, the FIR has already, my Lord, gone through it, and we have already found a pair. Now, my lord, I will take the lordship. The first epicenter of the case, my lord, may kindly come to the page number 46. My lord, 46.
No, I do not understand one thing, Mr. Modi.
My lord, I will try to
See,
clarify.
if when the matter is now settled in your favor, there was basically it was a civil dispute. There was a land where you are claiming, he was claiming also. And during that something happened, and there was some allegation that was. And I have seen this document. Only one statement they have written, which was wrong.
Apparently, my lord,
That was wrong, correct?
it appeared to
That was wrong, and like they have done it, and they admittedly they have stated that they have done it. But only thing is that now remaining is that now the civil suit that you have filed that has gone in your favor. Now what remains in the matter? I'm confused.
my lord, I will try to clarify.
No, please tell me to answer this. What remains in the matter?
My lord, to reach to that extent, my lord, I will go in the sequence, my lord. So first of all, my lord, that they, my lord, in page number 46,
No, you answer me this first. Wait,
My-
what remains? What remains in this matter?
my lord.
See, I have failed to understand. There was
Exactly, my lord. So,
there was no crime committed against you, first of all. Correct?
my lord.
It was a crime supposed to have committed against the state, if at all, because of forgery of the document and all these things. And your allegation is that like by forging that document, they claim certain portion of land. That issue has gone now. That issue has gone now because the civil court has decided the matter in your favor. You have got the right title over the land. So now he cannot claim that like this is my land also. Only thing is that one line has been written there, and like he has committed a mistake by not telling that fact before the tribunal.
Exactly, my lord.
That was the issue.
That
Now,
was the issue.
fighting this case, what will gain from there? Do you have any animosity against him?
No, my lord.
Yeah.
For that, no.
Yeah.
But what I am trying to my lord, display is that, my lord. Here is the case. The forgery is beyond reasonable doubt, my lord. They have admitted. Accused admitted.
The forgery, whether the case is made out, forgery. You
Ma-
will argue on this for how the case of forgery is made out.
My lord. That is why, my lord, I am trying to display the record. Start with the page number
Page
40.
46, you want
46, my lord.
46.
So rightly or wrongly, whatever the decision taken by the customary court is in page number 46.
46. Yeah.
Though, my lord, I am the, my lord, admittedly, I am the PI of the limiting, my lord. And to that extent also, my lord, I admit with that the PI should not be preceded the kebang called in the customary court.
Right.
But what is practiced in the state of Arunachal Pradesh, my lord, generally PI is, my lord, preceded the matter, and on that day also, he was the chairman. Therefore, my lord, we don't go. So coming back to the point, my lord, I will show, my lord, to page para 4, my lord.
Para 4 of the
Para 4 of the page number 42, my lord.
42 or 46.
Oh, 46, my lord.
Para 2, yes.
In the first para, my lord, he reflects himself that he was the chairman of that Keba along with the Piu Gambura. Now 46 said that it is found that a trial has been done through the relative to solve a case and between Xingming and the Mara recently. Hence, after considering the age of all the coded relation between both the family, Mara and the Xingming, and regarding the initiative action taken by the relative of both the family to solve this issue case, we, the bench of the judge, have appealed and advised both the party as below. My lord, there was no decision. They decide. Yes. They, my lord, appeal the compensation land against the 15 acres out of 19 be received from the Indian Army may be shared to the Xingming family in order to maintain their relationship. So, my lord, that was the proposal. Even out of the 15 acres be shared. If I agreed also, my lord, 15 acres is shared, my lord, then the 7.5 acres is to be in favor of my lord Sing Ming family. That was the, my lord, whatsoever that is the supposed. So my lord, even that also I was against this suppose also. So while I appeal the file that my brother has already revealed, the appeal file against this also. Now new subsequent documents what I can, my lord, in page number 47.
No, these facts are not disputed, Mr.
My lord, this is not disputed. What is the main disputed is, my lord, in page number 47.
This line,
Where this line has said that 15 acres of the land to the Sing Ming family. I never, even I was, my lord, objecting against the suppose also.
Mr. Modi, see,
Now, my lord,
no, I have heard this. Factually, I'm clear. Okay.
yes.
Now you just convince me that how these sections can be applicable to this case. The sections that have been put against the
Perhaps, my lord. Perhaps, my lord, admitted to that extent. But, my lord, is still, my lord, this system, this cannot be, my lord, allowed.
Let us go one by one. Sections. First, which are the sections?
420.
420.
Yes.
Let's see whether 420 is applicable. First is 420.
420.
Yes, 420, whether it's applicable. See, 420 is cheating.
My lord, cheating.
And cheating and dishonestly inducing delivery of property. Okay.
My lord, since I am the new one, 420 is in 318.
Hey,
Yes, 420, I got.
see, whoever cheats and thereby dishonestly induces the person received to deliver any property to any person or to make, alter or destroy the whole or any part of a valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security shall be punished. 420 is nowhere applicable to this case.
But despite that, my lord, the 15 acres of the land has been, my lord, they support.
Induces who? Induces somebody who is owning the property. Now, if he would have gone to Singling family, your client, what is your client? Mara.
Yes.
If he would have gone to Mara family and induces them fraudulently to give the land to him by forging a document, then fortuity would have been attractive. Here he has gone to somebody else. They do not own the property. They cannot deliver the property. So 420, in my opinion, 420 is not applicable to this case. Now let's go to the other section. Which other section?
468.
468.
468.
It's purpose of cheating.
Forgery for purpose of cheating.
Yes.
Whoever commits forgery, intending that document or electronic record forged shall be used for the purpose of cheating, shall be punished with imprisonment for either description for a term which may extend to 7 years and shall be liable to fine. So whether this section is applicable. You tell me how this section is applicable.
Madam. So, my lord, so far this intending that the documents to be used for the purpose of cheating, my lord. They have been used before the court, before the trial court.
But
Yes, my lord.
signatures are original signatures.
My lord, since from my inception, my lord, I am not saying that. I am saying that this is not the case that I am against the signature.
Correct.
But
no. In that case, whether a crime of forgery can be leveled against them.
My lord.
Forgery is something wherein you have really forged the document. You have forged the seal. You have put a seal which you have made in some shop. And the document has been created on the basis of that. Then
Well,
forgery will be applicable.
I agree with that, my lord. But what I am trying to, my lord, demonstrate is, my lord, that just for my satisfaction, I am questioning myself, my lord. The KEBA has taken the decision, and this decision was made by the, my lord, the chairman. But despite that, the opposite party has drafted the KEBA decision and thereby obtained the signature, my lord. So only the question lies here, my lord.
Only the misrepresentation.
Misrepresentation is there.
Misrepresentation, and that is
And
only thing.
completely, my lord, why I said that there is a perjury in the name of the, my lord, customary code. Customary code is the authority to decide or to draft the decision. But here in this case, the draft has been, the decision has been drafted by the party. And is this, my lord, permissible?
But this is-
For me, my
No,
lord,
no.
for
This
me,
is- no, see,
this is not permissible because
Mr. Modi, there is one difference. See, this is, what is this? This is a local KEBA discussion and statement. This is not an order.
this is
There is a difference between order of KEBA and there is a direction of KEBA and there is a discussion and statement. This is, see, this is a local KEBA discussion and statement. They are only showing that like this is, but Mr. Counsel,
my lord,
see, KEBA sitting report is already there.
my lord.
Then why you need to submit this? What
My
was the requirement for this document to submit?
That, my lord, I have stated in our,
No, you tell me what, why?
because those copies were not available to us, my lord. That
So-
report of the PI, my lord.
Report of the PI was not available to you?
Yes, it was never provided to us because there was no decision. It was not settled.
Then
So
when it was, how he has got this document?
that I am not aware. I have clearly stated in my petition that I came to learn about it only after the appeal was filed.
So you were not ever aware of this document?
No, my lord.
So you didn't have any document, so you went
Yes.
to the document?
Yes, my lord. Just to show that
Yes,
KEBA
but-
was not settled, my lord.
Yes, tell me.
so, my lord, they admitted that they were not aware of that. This report, but report filed by the chairman.
Report
And-
by the chairman.
Chairman.
They said they
And-
were not aware,
and-
but you were know about the procedure. It will be filed before the DC and he could have
And-
prepared the document.
And now they admitted that this is, my lord, that manufactured by them, my lord.
But
So that is only the question, my lord.
they are not disputing.
My lord, yes.
They are not disputing that they haven't done this document. They have not committed.
My lord. So only what is question remaining, my lord? The issue to be adjudicated by the lordship. What I am trying to display is that how, my lord, despite of the KEBA, despite of the customary code, how the other party should allow to, my lord, draft their decision for themselves.
No, there is no, I mean, see, I have heard.
In fact, my lord, luckily at this stage, my lord, the title should is in my favor. Otherwise, my lord, 15 acres of the land was supposed to taken away from me, my lord. That is
Yeah,
clearly, my lord, reflecting.
no, how it will be taken away? It was only a proposal. And you have
My lord.
denied.
That is proposal.
See, they are only saying that there was a discussion about this 15 acres of land, but it was not decided. That's what they are saying. How the land will go to them?
No, my lord.
like that.
What they
They
say,
are
my
also
lord,
saying that,
they
my lord,
say that I have
Offered,
offered them.
but they did not agree to
but
that.
we refused it.
They have said they have refused this. Now the issue gone.
So the KEBA was not settled, my
There
lord.
was
That
an
is-
offer, there was no acceptance. There is no contract.
Exactly,
Yeah.
that portion, my lord, I admit.
Yeah.
But what is remaining, my lord, they have not authority to draft this type of, my lord,
Only
decision,
that.
my lord.
Only that.
That
only
part,
that
my
part.
lord.
So I
So-
don't think, I don't think, Mr. Modi, I don't think this proceeding on the basis of this charge should go.
My lord. However, my lord, my submission would be, my lord,
They
if
have to
this,
overcome that
if my
bar
lord,
under section 195.
if my lord, if this type of, my lord, the petition is allowed, my lord, My submission would be, my lord. My lord, this will be open gate for the customary court to draft whichever the party required.
How can it be?
Exactly, how can it be, my lord? This draft should be, my lord, whatever the decision and the conclusion, that draft should be, my lord, chairman or the ground bureau. But this is the case that the other party has drafted in their favor and thereby obtained the signature from the ground bureau.
Now onwards, they will be cautious. Well, since this case has come to the fore, now the Gamburas will be cautious. They should not do it only on the saying of some parties.
And secondly, my lord, if we allowed, my lord, it will amount to, my lord, this undermine the position of the Gambura. Despite of the Gambura, whatsoever the decision should be drafted by the Gambura, not by the interested party. That part that I'm agree.
I fully agree with this. I'll fully agree with this. I'll record your submission.
And they have committed the misrepresentation.
Undermine the position of Gaur.
Customary court, ma'am.
Customary court and
Not
Gaur.
only that will be amount to undermine in installment.
That I agree. That I'll do. Yes.
And the proceeding will be put to the job. Customary court will be put to the, my lord, jeopardized.
But only thing is that, like, whatever charges have been framed, I'll have to see whether the charges have been properly framed or not. Whether the ingredients are there or not.
And
whether this that alleged offense gives certain ingredients so that, like, the charges can be framed. That is what I'll have to see. So I will pass on.
My lord. Finally, my lord, just two lines to conclude, my lord. What is the main issue before the lordship was just to, my lord, adjudicate the facts, the finding of the magistrate and the finding of the district judge. And
he
so,
has challenged that.
Yes, they have challenged. And their contention is that the finding of the district judge was error. And my lord, my submission is that there was nothing wrong in the order passed by the district judge, because the word direction was not there. Rather, the district judge has liberty to alter or frame any charge. The question was only that whether the action committed by the this accused petitioner now is liable to be prosecuted or not.
Yeah,
that has been finding of the district judge is
that I have already pointed out. That he only needs to see whether there is a probative value in the FIR or not, in the offense or not. If he sees that, like, there's a prima facie case, he can go ahead with the trial, and like trial will decide whether who is correct or wrong. But only thing is that, like, while framing this 4220 and 468, whether those will be applicable, because he should have used his mind. I mean, with his wisdom, he should have framed it. 420 is, in my opinion, after hearing all these people till now, though I'll have to write the system.
Yeah.
420 may not be. 468 we'll have to see. As we have also submitted. 420 may not be. So maybe it may be a case to remand back, wherein this we will frame the charge at first. That can be also one of the things.
That can, of course, issue on 195 is also,
Yeah, 195 is there.
Yeah, my lord. There is a clear bar, my lord. And it's mandatory, my lord.
So you have not submitted any case law on that. Because,
my lord,
see, this what happens is that from the reading of the sections,
my lord,
you do not know the interpretation of the courts.
my lord, that,
So
with that part, my lord, I will
there,
furnish.
there may be some interpretations of the court.
I will furnish by tomorrow, my lord. But if it's required, my
You submit it to me by tomorrow.
oh, yes, my lord, I will.
Ginny also, if you have anything. I can give it to you. You can give the print or citation will also do, but print is better because in my this thing, like, now they have not installed the SSC as yet, so it's difficult to take.
Because, my lord, this is a mandatory process which cannot be overlooked. It doesn't authorize any single, and just because so that.
I heard you.
Oh, my lord.
I mean, you would have taken a lot of time.
Well,
Heard Mr.
T sub 2.
So the learned counsel for the petitioner also heard Mr. Modi, C. Modi, learned counsel for the respondent number 2, as well as MS Genie, learned APP for the respondent number 1. Hearing concluded. Hearing concluded. Judgment and order reserved.
Item number 13.
Wait a minute. Where is your senior? He is waiting for some case. Just call him. What is the matter? 1 second. He's senior counsel waiting for a long time. See. Huh? Yes, sir. Service report, madam. Is there? Then we'll take up some other matter. Then we cannot wait. What is there in the matter? Item number 21. What is there today? I think service report has not come. Is it?
But we received city lordship.
Is there any service report? Has to be.
No lordship.
The service report on respond number 2. It has been served or not?
Sorry, lordship, I didn't go through the office note, lordship.
As per office note, service report is awaited.
Service reported on respondent number 2 is awaited, most probably.
Item number 13.
1-3.
In the NDPS case, matter, bail.
Lordship, this is for the granting of bail of accused person who was arrested by Chimpu police on 30 May 2025. Lordship, may
13 May?
30 May 2025. Lordship, may come to the FIR. That is in page 14, Lordship. 1-4.
Yes. FIR is at page
14, 1-4.
Yes.
May I read yours? With due respect, I hereby inform you that on 9 February 2024, Lordship, this is on 9 February, it was, FIR was lodged on 9 February 2024. At 15 hours, I got information from reliable source that Mr. So-and-so and his wife were selling drugs from the rented room at Gopur of Chimpu. I, along with Lady Constable Inya Gadi, left for the Gopur area. After reaching Gopur area, I have carried out reconnaissance and identified the house of Muhammad Hasinur Alam, that is the present accused person. I have managed 2 independent witnesses, namely so-and-so, so-and-so. They have voluntarily agreed to witness seizure, a search and seizure. After that, the house of Muhammad Hasinur Alam was visited. Muhammad Hasinur Alam was absent. That is a present accused person, Lordship. He was absent there. But his wife, namely Srimati Sofina Begum, 23 years, wife of so-and-so, village so-and-so, opposite. She allowed me and the Lady Constable Inya Gadi free ingress
to search her house in presence of the independent witnesses. The house was thoroughly searched and 99 numbers of plastic vials containing suspected heroin were found packed in 2 black polythene bags and concealed under the mattress of the bed. The suspected heroin in the oranges white powder were transferred to transparent 2 plastic pouches and made into homogeneous mixture. Net weight of the suspected heroin was found to be 17.8 grams.
Decided it, then,
The 10 gram of the heroin package in the plastic bag.
then,
Lordship, in this FIR, firstly, we can see that
no, he was absent, that's all. Nothing
yes,
else. Yeah,
yes. Thereafter, Lordship, may I come to page number 18. On this very day, the wife of the accused person was arrested, and she was granted bail on 10th April 2024. That is an extra 3 page.
No, when was this FIR file?
FIR was on 9th February 2024.
9 February 2024.
Yes, Lordship.
And this lady was given bail on
10th April 2024.
page
Number 18, Lordship.
18.
An extra 3.
10th April 2024.
Yes, Lordship. 10th April. 10th.
Bail granted to the wife,
Yes, Lordship.
granted to wife.
Yes, Lordship.
On what ground?
The ground is on page 19, Lordship. After hearing both the learned paragraph, after hearing both the learned counsel and perusing the CD, it appears to the husband of the accused. It appears that the husband of the accused, who is alleged to be main accused person, is still absconding, and the IO is yet to receive the FSL report. Therefore, taking cognizance into consideration of the fact of the
Okay, okay. Then,
thereafter, Lordship, annexure 4, page 20.
yes,
This is the arrest memo of the present accused person, the husband. The husband was arrested after,
page 20.
yes, page number 20. After
When
1 year,
arrested?
3 months. He
When
was,
you were absconding.
that is what prosecution says, Lordship.
No, what is your version?
My version is,
In
Lordship, that,
spite of knowing your wife is in, wife was
No, no.
arrested
no, Lordship.
under NDPS case, and like you were having, you were doing some party somewhere.
No, Lordship,
What-
here, what happened is that, when this present accused person came to know, this is his actually second wife, Lordship. When the present accused person came to know that his wife was arrested on NDPS, he had informed his father-in-law. And since there he came to know that 2 brothers of his father-in-law were already involved in the NDPS case. Therefore, he wanted to stay out of it. He tried to stay out of his wife, and he said that he don't want to live with his wife anymore since she is involved in drugs like controversy
You were
case.
not aware about.
Yes, he was not aware of,
this thing.
yes,
Now, so, with his wife innocent or like, I don't know,
yes, and
wife has been arrested. Now he doesn't want to have a relationship with her because he already has another wife. That's the case.
Lordship, entered this period, during the whole period, in the entire 2024, this present accused person was working within the premises of Chimpu PS only, within 1 kilometer radius of Chimpu PS only. He was working, I have specifically mentioned
He was working in Chimpu PS only.
in nearby Chimpu PS only.
Chimpu PS only when the arrest happened
Yes,
of his wife,
yes, and he was never absconding. He had never absconded. He was working there for a whole 1 year.
but he could not surrender.
No, he had no knowledge that there was case made against him.
His house is at Chimpu only.
Yes,
His house is at Chimpu.
yes,
His wife was arrested.
arrested, yes,
And he has been working nearby Chimpu,
yes.
but he was not aware that his wife was.
Okay. He was aware that his wife was arrested. He knew that
He
his
doesn't
wife
know-
was arrested on for NDPS case,
Ah.
but he did not know that the case was made against him as well. And in the FIR, his name is also there. He was not aware of that. Therefore, he was continuously working for a period of more than 1 year within this area. Earlier, he was working at,
After that, is there any document to show that he was working there?
no, Lordship, but I have
Can
specifically,
you show me some document that he has been working with some employee?
no,
That he
Lordship,
has been working with some construction company, he was working with some shop, where he was working?
no, Lordship, but I have specifically mentioned
I don't know where he was working.
there's no documents to show such that he was working there, but I have specifically mentioned the names.
Statement from where? From where you have made a statement? On oath you are saying?
The present, yes, the applicant is the brother-in-law of the accused person. He is a man contractor. Yeah, basically, he's Mr. Manson. So he's a contractor. So he was working with him for 1 year, whole 2024. Thereafter, again, he was working at Ganga. Lordship, please come to paragraph 5 of my bail application. I specifically mentioned that. Page number 4, paragraph 5. That the humble applicant begs to state that few days before the arrest of the alleged accused person's wife, that is on 9 February 2024, the husband and the wife had some arguments and didn't meet for a few days. Firstly, at the time of the at her arrest, the accused person was engaged in a construction work at Jew Road, Chimpu, Itanagar, under the present applicant, Sri Ikramul Hossain, who was then working as a contractor for one Sri Kiran Ringu. The alleged accused person had been working within the Itanagar area after the release of Safina Begum on bail on so and so. The alleged accused person has been working at the same site since January 2024 and continued there till December 2024. Thereafter, from March 2025, he was employed at another construction site at Ganga Basti. This is also near Chimpu, Itanagar, under one Mofidul Islam, a contractor working for one Sri Telihat. He remained engaged there till 26/5/2025. That is 4 days before the days of before his arrest. Now, after 26/5/2025, he went back to his home to celebrate Eid, and even on the way he met his wife as well. So throughout this 1 year, for last 1 year, he had met his wife several times because they have one child as well, who is at present 1 year 6 months old. So to provide his child, he had been meeting his wife several occasions, but neither his wife nor his father-in-law has ever informed him that there is a case against you. In fact, after release of this wife also, he tried to stay away from the wife because he didn't want to have any contact with a person who is already involved in NDPS case. However, only because of the child, he was in contact with the wife, and he had been meeting with the wife several occasions, Lordship. And if he had been absconding, he wouldn't have met his wife, Lordship. Lordship, this present the accused person, please come in para 12 of the bail application, Lordship. He has three children as of now, 3 minor children. Para 12. That the applicant begs to state that the alleged accused person has no previous criminal antecedents. He is the sole breadwinner of his family. He has 2 minor children, namely.
Got it.
Yes.
I heard it.
Now, Lordship, one more. Even if on prima facie, if we agree that the present accused person has involved in this case, yet again, Section 27 capital A does not attract author, Lordship. And if Section 27A does not attract, he has already languishing in jail for last 88 days.
Not last?
88 days.
And
Three
which section is not applicable?
27A, capital A, Lordship.
27A is what?
That is punishment for financing illicit traffic and harboring of the offenders.
Yes. 20. Now, which are the section under which this
21B,
Huh?
21B,
21B,
27 capital A,
27 capital A,
and then 29. Now,
29.
if 27 capital A does not attract,
27A also not a
yes, capital A.
27 capital A is punishment for illicit traffic and harboring offenders.
Yes, Lordship.
Punishment for financing illicit.
Here, in this regard, Lordship, financing and harboring, Lordship. There's one judgment.
Okay, what about 21B? 21B.
Lordship, my submission is that even if we accept the fact that he has been part of this or he had been involved in this drug trafficking, however, 27 capital A does not attract. And if
27A, but doesn't the but what about 21?
21 capital B,
And-
21B. 21B, the imprisonment that may extend to 10 years, Lordship.
Yes, and like what about section 29?
29, since there are 2 persons, husband and a wife,
Yeah.
punishment for abetment and criminal conspiracy.
So those sections are the those sections.
Yes,
are applicable.
if those sections are
Those
there,
sections will, I cannot go to the merit of the matter in the bill.
yes, Lordship.
The trial will decide.
Yes, Lordship. If those sections attract, and if 27 capital A does not attract,
The maximum period is 60 days, Lordship.
Maximum period is
60 days if the charge sheet has not been filed. So in this case, he has already served 88 days, Lordship. Lordship, just to understand the financing and trafficking.
no, that is that I got to know that
Okay.
may not be applicable. That
Then
may not be applicable. I'm not saying it will not be applicable. It may not be.
in that case, Lordship, he may be enlarged on bail because he has already served the maximum 60 days. And as of now, the charge sheet has not been filed yet.
What is the status of charges? CD has come now?
Yes, CD receipt, Your Lordship, investigation is pending, my lord.
What is the status?
Your Lordship, investigation pending, my lord. Because, Your Lordship, the person involved in this case, because they have stated and they are found to be involved in, Your Lordship, selling this contraband substance in peddling, my lord. And so far as the statement is also concerned, the wife has clearly stated. Now, after the release of the wife, Your Lordship, he has been arrested, my lord, the accused person. He was absconding, and the statement clearly, for the purpose of bail, my lord, the prima facie satisfaction, Your Lordship, 161 statement has to be taken into consideration. And the other material as such, Your Lordship, the wife has clearly stated that before coming, after getting information that police were coming on the way for search and he absconded, Your Lordship. And he remained abscond for entire more than 1 year, my lord. And recently, Your Lordship, in the month of, in this year, 2025 only, the FIR was initially registered in 2024, my lord, in February, my lord. In 2025, my lord, in the month of April, May, my lord, he was arrested, my lord. And Your Lordship, the contraband substance has been sent for FSL, my lord, the forensic lab test, which is awaited, my lord.
FSL report is awaited.
Awaited, Your Lordship.
What investigation have we have done?
Your Lordship, the investigation, Your Lordship, the contraband substance has been sealed and the other procedure as by 52A. All this part has been done, my lord. Because for sending the contraband substance for this forensic test also, Your Lordship, 52 has to be.
There is a procedure.
Yes, Your Lordship, procedure part. And then, so far as the procedure part is concerned, they are not assailing it, and that cannot be assailed at this stage because, Your Lordship, that question has to be raised during the trial, Your Lordship, whether it's been properly done or not. Now, the expect, as Your Lordship has rightly pointed out, my lord, the prima facie case is there or not, my lord. So now, Your Lordship, the statement is concerned, the contraband has been duly seized from the.
Okay, no, see, I just wanted to know from you is that FSL is awaited.
Yes, Your Lordship.
FSL is awaited, investigation is on. Charge sheet has not been filed.
Yes, Your Lordship. And Your Lordship, when section 27A comes, my lord, the section 37 comes, and Your Lordship, the investigation period would be 180 days, my lord, and which can be extended.
That is what I wanted to see. Where is that?
Yes, Your Lordship, section 36, Your Lordship, of the NDPS Act, my lord.
Section 36.
36A, my lord. In 36A, subsection 4, my lord. Subsection 4, my lord. Thirty-six capital A, my lord.
36 capital A.
Subsection 4, my lord. May I read, my lord?
Yes.
In respect of a person accused of an offence punishable under section 19 or section 24 or section 27A or for the offence involving commercial quantity, the reference in subsection 2 of section 167, now Your Lordship 187 of CRPC or BNSS, they are of 290 days where they occur shall be constituted reference to 180 days, my lord. Provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year of the report of the public prosecutor indicating the progress of the investigation and specific reason for detention of the accused beyond the said period of 180 days. Now, Your Lord, my lord, the first thing is the Your Lordship, this prima facie satisfaction, and second part is, my lord, the material so collected during the course of investigation. As Your Lordship, I have already apprised Your Lordship, this investigation is still pending, my lord. But prima facie so far as
the investigation is still pending.
Yes.
We cannot decide whether section
20, yes,
27A
A will be attracted or not? Yes, yes.
Yet to be completed.
Yes, Your
So
Lordship.
there may be materials coming before the IO
Yes, Your Lordship.
that he is financing also. How do
Yes.
you know?
But prima facie, my lord, is there because they have clearly stated that they are involved in selling of this contraband substance.
Thank you for assisting the court.
Lordship.
Fine.
Yes,
So I'll pass the order.
Lordship.
Then I'm not inclined to release on bail at this stage. 180 days, as in, I mean, it's only 66 days, you said, right?
88 days, my lord.
88 days.
Yes,
NDPS matter, the procedural things takes lot of time.
yes, yes.
Sampling and taking the certificate from the judicial magistrate, a lot of things.
Yes,
So
and CDR also, my lord. Lordship, that is
heard Mr. So and so. Learned counsel to the petitioner, as well as Mr. T.A.K. learned APP for the respondent state. I'll pass the order. Order will be passed.
my lord, CD.
Give me the copy.
Yes. I mark the statement, my lord. Their statement.
I'll consider this also.
Lordship. Lordship, in the affair, there is nothing to show.
A scan, a copy of the CD, scan copy of the CD is produced by the. Then keep it incomplete. I'll pass the order. But but it will be rejected. Don't take
Perhaps,
it
Your Lordship, no authority is required from our end. Your Lord. No authority is required from our end, Your Lordship, for yes, citation judgment, my lord. It's not, perhaps not required, Your Lordship. I have the judgment, Your Lordship, on section 37 and on.
You can give it to me. It's always good if you can support your thing with
Yes, Your
some legal pronouncement.
On section 37, my lord, two judgments, that's it, Your Lord.
Yes. You have the paragraph?
Yes, yes, my lord.
This 2007 SCC
2007 SCC, my lord.
that Union of India versus Shankar Kesri.
Enter people.
You have you just give it to me.
My lord, there are 6, 7, and 11, 12. May I read out? There are 6.
No, there are 6,
Yes, Your Lordship.
11,
6, 7,
6, 7,
11, and 12, my lord.
11 and 12.
Yes. And in
Other
other.
one? The
Kazat.
State of MP versus Kazat.
Yeah, Kazat, Your Lordship, it's Kazat, in my lord, there are 5 and 6, my lord.
There are 5 and 6.
Yes, my lord. That's it.
What's the order?
Obliged.
Item number 21.
Yes, Mr. Sakya, I think service is awaited here.
Services awaited the interim that was that
Are you going back today? Or? You could have mentioned there, you could have told me.
No, we have time.
Only services awaited. I could have passed the
Other than going by train only. But
and there is nothing else, no? It's only services.
service awaited and the interim that has been passed by the country.
Third, Mr. P.J. Sakya, London Senior Counsel, assisted by Mr. P. Baudelaire for the petitioner. Also heard Mr. D. Loy, learned PPP for the state of Arunachal Pradesh. Seen the office order dated, seen the office note dated 25/8/2025. This shows that service report, respondent number 2, service report, notice of service report as per notice on respondent number 2 is yet to be received. List this matter after 2 weeks. Interim order so far. Interim order was there.
Yes. The courtship, no courtship action, lordship, but sometimes it's courtship action misconstrued.
Sorry?
The courtship action may not be taken
is sometimes misconstrued lordship and misapplied lordship.
No
Yes,
question.
since investigation is going on lordship. The only thing is that you should not take any coercive action. If there is an order passed by this honorable. Earlier also I raised objection lordship. I'll leave up to you. Investigation we can carry on. Only thing is that if you did not take coercive action such as arresting him, doing this, that we should not do that. So, this fine is on our earlier order, interim order so passed on 23/7/2025 is extended till the next date. Any fixed date you would require?
Since 2 weeks has given, so fixed date.
Next date. So I'll make it.
Further order can be made. Until further order can be made.
No, make it next. But it's a
Next date of listing in that place.
It's a proxy matter.
No. It's a FIR sought to be quashed under section 420. That's a purely a civil dispute. And perhaps
Make it until further orders.
PP also having the CD, perhaps that may be retained. And if I am permitted to take additionally, the usual course, steps by usual course, additionally.
Okay. Learned, your name, Mr. P. Bodley, learned counsel, assisting Mr. PJ Saikia, will take fresh steps or
steps additionally.
Take additional steps additionally in usual course. In usual course, full stop. And the case diary so received by the learned PP will be retained till the next day.
Obviously.
Okay. Item number 14.
Please, your lordship. Lordship, my matter, lordship, it's almost similar to item number 11, lordship. Your lordship has dealt.
Some additional affidavit you filed over.
Lordship, I have filed one additional affidavit, bringing on records the FIR that was furnished to me. They, in fact, after getting an order from this honorable court, lordship, in fact, the police came to arrest me, lordship. However, after showing this order, lordship, they did not arrest me, of course, lordship. And then this FIR was furnished to me, lordship.
Where is the FIR?
Lordship, FIR, lordship will find in my additional affidavit at page 34, lordship. This written FIR was furnished to me, lordship. Not complete FIR, but written FIR. Now this FIR is of 17/7/2025, lordship would see.
Yes, what are the allegations?
Allegations is, lordship, in the subject itself, lordship will see, lordship, FIR against me for forgery, domestic violence, illegal entry into a second marriage. I am reading, lordship, the whole FIR. I am to inform you that I have married to Toko Tanya, son of Toko Rebia, village Dodo Post, so 17 July 2012, lordship. As per NISI, customary laws and practices. Out of our wedlock, blessed with a male child, namely Toko Kapum, were born. Presently, he is serving as a consultant under Swachh Bharat Mission in Public Health Engineering Department under Yachuli Public Health Engineering Department and Water Supply Division. This is not correct. I am serving in Itanagar, actually. My husband is a champion of extramarital affairs with another woman. He abandoned me and my son, leaving us in a destitute and helpless condition. Accordingly, a local manual was held on so-and-so to so-and-so, and this is of 2020, lordship, and 18/9/2020 to 19/9/2020, wherein parties had agreed to divorce one another mutually. Lordship may kindly note. But my husband did not agree the decision and went off. There was an agreement that was drafted, lordship. Certain terms and conditions was not agreed upon. So why I did not sign, lordship?
He did not look after me and my son. As a result, I was compelled to sold out local ornaments given by my parents, gas cylinder, and also second-hand car to meet expenditure incurred on medical, daily needs, education, fees for myself and my child. Finding no alternate to manage our two ends, I have filed maintenance case against my husband before the Judicial Magistrate First Class, UPA, Papumpare District, Arunachal Pradesh, by maintenance case number 42 of 2022. In response to my maintenance application, he has annexed at Annexure 1 P14 a document titled as Case Mediators cum Gaumburas Declaration. I have carefully gone through the content and found that my husband has forged my signature. Lordship, may kindly notice, Lordship, she is alleging that I have forged her signature also, Lordship. As well as seal and signature of Gamburas and Gamburis. They are namely so and so, so and so, so and so. These are all the list of the name of the Gamburas. And falsely made that mutual divorce process was completed at Talo. Here I am to inform you that mutual divorce was not done till date. Instead of taking care of me and my child, my husband has committed serious offense by forging the seals and signature of public servants. Besides this, he is mentally, physically harassing me from time to time so that I can give divorce to him. Further, my husband has made a false declaration before the marriage officer, although that he has solemnized such marriage with Miss Yompi Nyoru, 24/12/2008 at Talo village, and fraudulently obtained marriage certificate. My husband could have disclosed the truth about his first marriage, but he has misled the lawful public servant and about his first wife and children. And also my husband, being government employee, own a registered contractor firm in the name and style of MSJ Enterprise, which is also illegal. Having done this, my husband has committed forged the seal and signature of Gamburas, who are public servant under the law. He forged my signature and also subjected cruelty against me and my children. Also, he has marrying again in my lifetime as legally wedded wife by performing marriage ceremony fraudulently. Since offense has been committed by husband at Talo village, hence filing this FIR before your good office for prompt justice. Therefore, sir, you are requested to register a case against my husband, namely Sri Chotam Toko Tania, for cruelty against me and my children, fraudulently entering into second marriage, forged my signature, forged the seal and signature of public servants, and booked him under the provisions law of play. This is the content of the FIR.
Which is what is page 40?
Lordship, page 40 is another FIR that has been filed by the Gamburas. Now, in this FIR, Lordship will get the clear picture that the seal and signature was never forged, Lordship. But then the content was written by me. That I have clearly admitted in my application also, Lordship, in my bail application also. The content was written by me, explained to them properly, and then taken their signature.
No, this FIR.
After the wife has registered, filed a complaint, subsequently this Gamburas they have filed.
What are the what they have?
All the facts is almost similar. Drafting is this similar only, Lordship. I'll just take Lordship to the relevant para, Lordship. Page 40, last paragraph. The case mediators cum gam declaration dated is a self-manufactured documents. Some of the seals and signature on it are forged seals and signature. They are not specific that my signature, his signature has been forged. In my wife's complaint application also, she has clearly stated that I have forged her signature also. But Lordship will find that in that particular declaration, there is no signature or seal of my wife, Lordship. Toko Tania has obtained the seal and signature of the Gambura by concealing the contents of the documents and misleading the Gambura through misrepresentation. Now, the basic allegations of the Gamburas are that the content of the declaration was never explained to them and their signature was taken accordingly. It has come to notice has filed a maintenance case so and so so and so. A copy of mediature come from that is an application addressing the executive magistrate actually for paying. Now these particular documents, Lordship, which I have annexed in my application, Lordship, will find that
What is this FIR in page 48?
this page 48, Lordship. Since there was a marital discord between my first wife and the second wife, Lordship, they came to my place and they assaulted my wife, Lordship, who is my second wife now, Lordship. They assaulted me. In lieu of that assault, Lordship, this FIR was filed by my wife, Lordship, present wife, Lordship.
Your present wife has filed an FIR against your earlier wife.
Earlier wife, they came to my place.
Which allegedly hasn't been broken as yet because no mutual agreement.
Lordship, in the mail was conducted, divorce settlement was done.
So you have gone to the court and argued the case, but no judgment has been passed. But like you still thought that like okay, judgment has been passed. I got the divorce, thing like that.
Lordship, that mutual divorce agreement, Lordship, the signing part only was not done since certain terms and conditions was not agreed by the husband. Lord.
Your case is basically that misleading part and like misrepresentation, that is fine. But what about your wife's this thing? Wife's FIR where she is saying that he and all these things.
Lordship, in fact, that maintenance case is pending before the Lanat JMFC court, Lordship.
But that doesn't mean that like you will try to assault her or like.
Nothing like that, Lordship. We are living separately, Lordship, for the last 5 years, Lordship. Lordship, after lodging of this FIR by my second wife, Lordship, we are not staying together. In fact, after the NIL, Lordship, I'm submitting, Lordship, on oath, Lordship, that we are not living together, Lordship.
So this is the mutual divorce agreement, na? Page 13. What is this?
Yes, page 13, Lordship.
So this was drafted by you and.
No, not by me, Lordship.
Who?
By them, Lordship.
By?
By the wife's party.
By the wife's party, but you
Lordship.
did not agree, so it was not.
Lordship, certain terms and condition was not.
No, it never happened. So what is the value of this? Now this case of mediators from Gambura, this one was created by page 21.
Lordship.
Page 21 is done by whom?
Lordship, this all signature and all, Lordship, they are done by the Gambura Assembly, Lordship. The content I have drafted, Lordship. Copy was circulated also, Lordship. And this very documents was part of the maintenance case also, Lordship. We have annexed this as one of the annexures in our WS, Lordship.
You read the contents of this
Declaration. Yes, Lordship. In reference to marital dispute hence we the Talo village and the other village Gamburas and Gamburis being a village level judicial authority has settled the matter within the village level in mutually and amicable between the parties, had conducted local mail Gavang at the residence of Tokor Lalin, elder brother at Talo village on so and so date, and local mail had conducted 2 days on 18/9/2020 or 19/9/2020 under the control and supervision of GVs. The matter had settled for mutual divorce cum declaration. But Srimati Lokor Likha Ako and her party had hidden writing the terms and condition of agreement divorce cum declaration without the presence of mediators and Toko Tanya family member, but only correction of agreement and handover all documents of Sri Toko Tanya is left. The mutual divorce had settled on so and so in both parties, but no further case on this dispute in near future. Only documents excess is left. We are try to settle very shortly on local level. Whereas Sri Toko Tanya had sincere and decently response the dispute of the case, we have releasing him to join the posted place which effect from 24/09/2020. Lordship, by this declaration also, it becomes very clear that signing part only is remaining, Lordship. The mutual divorce part is completed, Lordship. Only signing part is left because I have not come to the certain terms and condition, Lordship.
But
That certain terms and condition is,
This is the document which was supposed to be for.
Lordship, this is, yes, Lordship.
This was not done before the Gambura.
Lordship, the sign and signature, it was done before the Kamburas only.
But like the contents are totally different. That's why they have gone to the, they have filed an FIR. Because of that only they have filed an FIR, no? Because contents were totally different.
No,
Yes.
Lordship, we received CD, Lordship. May I read the CD or Lordship will pair with Lordship?
So what is there?
Lordship, so far the IO has recorded the statement of these Gaburas, Lordship.
What they have said?
Lordship, they said that this document, page number 21, was misrepresented by the applicant by saying that he is going to join his postal place of posting. So he need clearance from the Gaburas. May I read the statement of the Gaburas? Seven Gaubura examine, Lordship. One of them, Lordship.
You read one
Yes.
Gambura, no?
I am Gambura of Talobles. My statement is that a traditional court known as mail in our Nisi language was convened at Talobeles for 2 days. That is on 18/9/2020 and 19/9/2020. In connection with the matrimonial dispute between Srimati Lika Akot Toko and her husband Sri Toko Tania, son of so and so. The mail was conducted under the supervision of blessed authorities, GBs, in the presence of both the Lika, Tako, and Toko families of wives and husband. After detailed discussion, the member present, including both the husband and wife, decided to enter into an agreement for mutual separation in the order to end all the confrontation and allow each party to live peacefully without interference thereafter. The decision was nearly finalized and drafted on the non-judicial stamp paper to be executed before the magistrate. However, Sri Toko Tania, the present applicant, refused to sign the document and left the gathering. The agreement paper was then handed over to Sri Toko but to persuade his brother to sign. But after a long delay, the document was returned unsigned by Tania, rendering it null and void. Consequently, no final settlement could be reached. To our surprise, we recently came to know that Srimati Lika Akoto has lodged an FIR against the GBs, alleging that we furnished a false declaration paper to her husband, Sri Toko Tania. It has also been reported that he used the said paper in court to counter the maintenance claim raised by her for their son. This act is a grave insult to our institution and amongst the gross betrayal by Sri Toko Tania. The question of mutual divorce execution does not arise, as Sri Toko Tania himself refused to agree to the settlement. He deceived us by obtaining our signature on a paper without disclosing its true content. He merely informed us that he required a release letter from the GBs who attend the meeting so that he could rejoin his duty at Pangin.
Okay, hand over the CD to
Yes. Lordship, I plagued the operative.
I'll pass the order. I'll go through the CD.
Yes. Lordship, one small submission. Lordship, this is a case of
He
misrepresentation.
is working as well. No, this is not a case of only a misrepresentation. Misrepresentation for what? I mean, misrepresentation. See, misrepresentation also has the gravities and degrees. You misrepresent saying that I wanted to have the chocolate, but I got this thing. You tell somebody that I will have only the, I mean, like that 10 paisa candy, but like saying that you had that 100 rupees chocolate, that is also one kind of misrepresentation. And here the misrepresentation is that like you say that like you will be, you need the signature because you need to join the job. And I need that's why you need a kind of a certificate from the Gamburas. And on the basis of that, the Gamburas have given you, but you have written something else there. You have written about the mutual agreement and like the divorce and all. So this representation are totally different. We cannot see there are some grades of misrepresentation. By misrepresenting yourself, you have taken a mutual divorce agreement. And plus, you have submitted the document, you used that document before the court for maintenance purpose also. That is not a small misrepresentation, a minor misrepresentation.
Lordship may kindly appreciate.
No, I'm not going to hear you anything. You have to say anything else than this, tell me. You disagree with me, then you tell me.
Lordship, the facts are a bit, I have to apprise the facts, Lordship. Facts are not like.
See, facts, I know. There were some marital discord, there were some issues, that happens. Then mutual agreement is supposed to be signed. Then something happened, one person hasn't signed. That is still there also, there is not a problem at all. So once it is not signed, though the person earlier agreed for mutual divorce, and certain terms and conditions we did not agree. So the mutual agreement was not signed. Now you have given a document stating that like mutual agreement has happened. And that document you have taken from the Gamburas, misrepresenting that you need this city of their signatures for a different purpose. We have not said that like it's for marriage purpose or like settlement of this thing or regarding our discussions on the particular date. You stated that you wanted this for a different purpose, for joining your job. But you have written there about the mutual divorce, a statement about mutual divorce. Those things are not mere misrepresentation.
Lordship, may I highlight this?
You have cheated. You have cheated the Congress.
Yes, Lordship, basing on this first document, Lordship, they enter into second marriage, Lordship. Wherein the marriage recorder also raised objection, Lordship. Lordship, CD was properly paginated, Lordship.
This is there in case of
no, not part of the CD, Lordship. So the marriage registrar issue notice to the applicant, Lordship.
He saw it to him. Get you right, heard Mr. So and so, also heard Mr. Lowy for Lowy Leonard PP. Order I'll pass later on. No, you don't need to write anything. Only thing that you record this case diary has been submitted to the court as well as one document dated 25th August 2025 by the magistrate marriage recorder district West Siang Alo to Jottam Toko Tania, who is the petitioner. Just note down this, then I'll pass the order.
Lordship is, if I may be permitted 1 or 2 minutes, Lordship. Just I'll highlight the facts.
No, nothing is there. The facts I'm aware of. Facts I'm aware of. If I need something, then I will let you know.
All right.
And this is marked as action and kept on record.
Item number 18.
I will not take any more. No time for today. We keep it for tomorrow. Keep it for tomorrow. What is it? Another question.
Item number 24, understood matter.
Like, can I rise for 5 minutes? I'll come back in 5 minutes. Just for 5 minutes, give me. Just give me 5 minutes.
For 18.
What is there?
Also, today this matter was listed for the respondent to file objection. But it seems the opposite.
Affidavit in opposition is not with time.
Yeah.
Mr. So-and-so learned counsel appearing on behalf, appearing for the petitioner. You're for petitioner or
Yes.
appears on behalf of the petitioner and who is the respondent?
It seems they are absent.
Non-appears for the respondent. He seen from the office report dated 25/8/2000, office number dated 25/8/2055, that an affidavit in opposition was to be filed by the sole respondent, which had not been filed as yet. The matter is adjourned for 2 weeks.
Lordship, there's an interim order in this matter.
The interim order show passed earlier. Shall continue in the next date of
Item number 24, unlisted motion matter.
May I please?
Anticipatory bill.
Yes, my lord. My lord,
You have the affidavit here?
my lord, here only notice, page number,
Is on the
notice under the 35 clause 3 of PNSS. This notice was served by the Dimapur Women Police while he arrived at Nahalagan to rescue the minor child. In fact, my lord, in this case, one person, one lady who pretend to be a biological mother of that minor child, he appeared before the present petitioner with the tear eyes, repeatedly approaching to the petitioner, saying that she belongs to down-to-the family. And he approaches repeatedly with the tear eyes to the present petitioner to take the custody for some time. And beside the pretend to be biological mother, yes, taking the custody of the child, along with one another person who pretend to be uncle of that minor child. While taking after repeated approach, the present petitioner, who is a uneducated homemaker, he accepted her approach, and while taking the custody, he executed one agreement, that is custody custodial agreement. I have annexed the case. After that, it was learned that that the minor child is not belongs to that person who pretended to be a biological mother. Then and there, the present petitioner gave one separate point to that minor son, minor daughter, that if you are not if you are not biological daughter of that mother, you can communicate your original parents. Then minor child repeatedly try for a weeks, then dial another number. Finally, ultimately, she could contacted to her biological mother, who is residing at Dimapur. Then and there, this case was registered at Dimapur, and team of the Nagaland police come to the Nahalagan and they take the custody.
This person, petitioner stays in Nahal.
Yes, petitioner residing at the Nahalagan Lower Model Village.
And the lady who has come with the minor child,
It was from Nagaland.
she's from Nagaland.
Yes, yes.
She came here.
Yes, he came here
She
with
came
minor
here
child.
and how do you know her?
We have don't any connection with that lady prior to the taking of custody of that minor child.
Without knowing the person. Only because somebody came to you, she cried, they take the custody of my child, you have taken the custody.
One lady was there, Mistress Hiling Pina. She brought that minor child and who pretend to be a uncle and pretend to be a biological mother. This is by agreement. I have annexed that agreement. Mistress Hiling Pina, who brought that
Who is
person?
who is Valentina?
That is just neighbor to the present petitioner.
So that lady has got this child and the uncle of the child.
Yes, yes, yes.
And the mother,
Exactly.
supposedly biological mother to you.
Yes. So well.
And she introduced her to you.
Yes.
And you accepted it.
Yes.
You accepted and like you have signed an agreement also
Yes.
for custody.
Yes. So that was blind belief on my neighbors and that biological who pretend to be biological mother. So on their repeated approach, the present petitioner accepted and takes the custody for some time.
Where is the agreement?
Page number 11 in my application.
It was signed when?
Page number 12. And last page number 12. Last
July 2020.
5th of July. Say
5th of July 2025.
5th of July 2025. Where is the date?
In the initial line
5th of July 2025. 5th of July 2025.
this is a present petitioner. Tayo Kusum is the present petitioner. And the birth certificate is she is the mother of 1.5 year minor baby.
Present petitioner.
Yes, present petitioner.
Petitioner is the
Lactating mother.
Huh?
Lactating mother of 1.5 year baby.
she is a lady.
Yes, she is a lady. So page this next one is the notice served by the Nagaland police. So that the date of appearance is given as 29/8/2025. So my humble prayer before this humble court. So since notice is issued by the police, so being a law-abiding person, I have to appear before the police. So being a lactating mother, while traveling from Arunachal to Nagaland, there is apprehension for arrest because Nagaland police appeared in Nagaland police station. Nagaland police requested me to go with them on that day, but I refused. To go with them on that day. Yes, on that day. Because custody, I voluntarily I gave the minor child custody to the police through OCPS Nahalagan. Because that is my fully cooperation to the Nagaland police. Because when this agreement, child is already the custody given to the biological mother through Nagaland police.
Yes.
Yes, Your Lordship, this is actually a transit anticipatory bail, Your Lordship. Your Lordship, otherwise, I don't have any objection if only for the limited period of he appear before the IO of the case and then file a appropriate bail application before the Nagaland High Court bench, Your Lordship.
So you will go and appear there.
Yes, I will go. I'll definitely I will appear before the eye of the
And
case.
file appropriate petition.
Yes, till file appropriate application, I may be protected.
What about the other one?
Other one is same. This is other application. Is the only witness. That is Rending Tayo Yamin, who is witness in this while executing this guardianship agreement.
Witness.
Yes, witness.
He is also given the notice.
Yes.
He also ready.
Yes, he also ready. I have annexed that mother and child protection card issued by the hospital. So in this case also, this petitioner also, she is a mother of 3 years baby.
What are
So-
the conditions to the
Your Lordship, the conditions prescribed as per the anticipatory bail sections, Your Lordship, adding adding to the fact that only the limited period, because since this is an interim, that will be an interim order, Your Lordship, only till when he.
So when can you appear there?
That is fixed 29th of this month.
29.
And 29 is Friday. And Saturday, Sunday, it will be approved. By next September 2nd and 3rd, I could appear before the appropriate court for regularization or
Yes.
press application. Okay, 29 Friday.
29 is the next date fixed, right?
Yes, yes.
Can't appear on 29.
No, I will appear. I can appear 29 because that is fixed by the police. So in a
Appear there on,
yes.
and from 29, once you appear there on 29, it's another 1 week time. So it's file
Exactly.
before approval.
Appropriate court, yes, sir.
That
That can be done.
So 29 he appear, and by first week of
September.
September, yeah, he will be. That takes some time to find a bail application.
The Lordship can.
In September first week, that is 6th till 6th of September, that is Friday. Within that period, I could file the appropriate application. 29 is a Friday, so Saturday, Sunday it cannot be.
Saturday, Sunday, and Monday seems to be a holiday, Your Lordship. So until the first week of September, Your Lordship.
First week of September, we will do it. So I will give you a date, first week of September.
Yes.
If you do not approach the court there, then the bail will be automatically.
Yes.
Yes, you can say.
Yes, my lord, transit available only limited
What-
period. I can.
Bail bond, so
That would be before the
Nagaland police.
Nagaland Police, Your Lordship.
So how do I do that?
As per the satisfactory of the investment team, what they are asked to produce.
No, that
No.
I have to order here.
Yes.
It's not
Uh, if I may suggest, your lordship, if your lordship picks a particular bail bond amount, your lordship, to the and shall be submitted, and sure, even with a surety, your lordship, submitted as per the satisfaction of the investigation officer of the.
That is fine, because whether he be able to manage security there.
Security, my lord, that is impossible because I never been Nagaland. So because the petitioner, both of the petitioner is a homemaker, that is housewife or uneducated one. So that is impossible for them to manage security from that locality.
Not locality, your lordship, surety, like, for example, if there is any government servant, even from any states, your lordship, that would also suffice. This need not be a local, because it's seen, your lordship, this is a state to state bail, your lordship.
How he is going to manage it from there now, there?
This, any government, if any government official is there, your lordship, if they can take, there might be some in the family, I guess, so, your lordship.
See, if the problem is that like, if he cannot file it, then like his bail will not given, because the purpose of giving is that his bail will not be served. So we have to arrange somebody to.
I'll try because since we protected, definitely we can manage somehow.
Protecting is fine.
Yes.
I protect when like pass an order. And like if the order cannot be executed there, we will not get a security guard in. What is the purpose of doing the giving?
Exactly. My lord, any relatives, any family members, because the both are the wives, so if both the husband can be a surety, then it will be appropriate and it will be responsible person to produce agent when required by the police or trial court.
That can be done. I allow this develop to be please.
Highly obliged.
You have done the names and I saw the order.
Yeah.